Hello, everyone, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd, and as you see from my shirt, I'm wearing my Sin City Motorsports. Why? Because what you're about to witness is a god-awful sin. I'm going to show you the disparity between the haves and the have-nots. We're going to dive into Kelli Johnson. I profiled her twice on my show. She is a 178th Judicial District Court of Harris County, Texas, presiding judge. She's had two law enforcement encounters. The first one, she skated by. The second one, they arrested her in less than 2 or 3 months. So we're going to dive into that. And I'm going to show y'all what this looks like, okay? Where there's corruption, there's fraud. I'm putting it on Front Street, folks. I'm not going to play around. I'm not going to dibble-dabble. I'm going to put it out there. So get ready for that. Well, let me get over here and open something else for you guys real quick. Whoops, up here at the top. Boy, this thing's running slow today. $7:30 Central Time tonight. Debut. Criminal exposure of Scam Anderson, aka J-Boy Productions. Texas and U.S. felonies violated. Are you a participant or a victim? Stay tuned for that 3-hour and 11-minute expose on Sam Anderson and his violations of the law. Very enlightening. In that video, we will discuss harassment, cyber stalking, statute of limitations under Texas law, criminal street gangs as defined by the Texas Penal Code. Then we'll move on to Title 18 U.S. codes, which is the criminal codes for the federal government. Again, harassment, cyber stalking, wire fraud, mail fraud, criminal street gang, RICO Act. That's what we're going to cover. So, for those of you who don't know, law is my bailiwick. I'm very powerful in law. I've studied my ass off. I fought these as hard as I could. Okay. I got to hold my tongue. So let me dive over here and get the show started of what exactly is going on, why I want to address this. And again, folks, okay, I didn't pick the topic for the show. I had no idea what I was going to do today. And boom, it's dropped in my lap. So for the last hour, I've been preparing the show, and I'm going to try to put on the best presentation I can for you guys to show you actual real-time corruption in Harris County courts. 100%. I'm going to show you without a shadow of a doubt that I have been wrongfully convicted. I'm not actually innocent because I could be convicted of a misdemeanor DWI, not a felony DWI. But again, we would have to go back to a retrial. The evidence in my case does not support a felony DWI conviction. And I'm going to prove it to you. I'm going to show you the case law from the Court of Criminal Appeals. I'm going to show you the actual statutes and codes of the Texas Penal Code, or section 4904 and 4909, which is enhanced penalties offenses and penalties for a repeat DWI offender. I'm going to show you what a mandate looks like, because I always talk about mandates, and most of you don't know what a mandate is, never seen a mandate, never heard of a mandate. So I'm going to show you that. I'm also going to go through the Dun & Bradstreet background business report for the judiciary courts of the state of Texas. I'm looking for something else. I can't seem to find it. Let me see if this is it. I'm doing a search. Sometime today. Oh, well, I'll leave that up there. That's not what I was looking for. Let me try this. See if that'll find it. Sorry about that. I was doing a search while I was getting ready for this. So let me dive into the article. Harris County Judge Kelli Johnson's DWI charge to be dismissed. This is by Nicole Hensley, September 10th, 2024, 1:50 p.m. Judge Kelli Johnson suffered a brain injury at some point prior to accounts of bizarre, and that's the illustrious lesbian. She is gay, the first gay judge to sit on a bench in Harris County. 178th District Judge Kelli Johnson on the bench as she goes through her docket Friday, July 19th, 2024, at the Harris County Criminal Courthouse in Houston. Okay. What she has done, what this woman right here has done because of her elitist criminal behavior, and I'm calling her out. I am. Okay. Right there. She is a criminal. This is criminal behavior. Judge. This is Michael Wick or White, contributor. So I got to give those accolades where they are due. Judge Kelli Johnson's Oh, y'all want to play that, huh? All right, hang on. Houston Chronicle sucks. All right, here we go. Try this again. Oh, no, that's not where I wanted to go. That's where I wanted to go. All right, here we go. Back to it. Sorry about that. Judge Kelli Johnson's misdemeanor DWI charge was dismissed Tuesday after a toxicology report failed to reveal any signs of alcohol or drugs in her system at the time of her June arrest. One of two traffic stops that coincided with accounts of bizarre behavior, her defense attorney said. Okay, now I want you to listen to this real carefully. Okay, what they did not find was what? Alcohol or drugs. And we're going to get into that here in a minute. Okay, when I go through the elements of the offense for a misdemeanor DWI pursuant to the Texas Penal Code, Section 4904. All right. Johnson's defense attorney, Chris Tritico, addressed the dismissal on her behalf, said Johnson also hopes to return to the bench after recovering from a brain injury. That's a quote. Montgomery County District Attorney Brett Lejeune. Okay. Let me tell y'all about Brett. I've gone up against Brett. Abso-fucking-lutely. Brett is corrupt as well. Okay. Don't for a minute think he's not. These district attorneys are fucking corrupt. We can go down to Galveston County with Jack Rohde, who used to be an assistant district attorney for Harris County. Well, guess who went up against Jack Rohde? I did. That's why I tell you, folks, I've gone against all of these people. Mano a mano. Abso-fucking-lutely. Go back and read my record. I sued Jack Rohde. That's how badass I am. Montgomery County, corruptly, Brett Lejeune, whose prosecutors took over the case after the recusal of Harris County lawyers, signed the motion to dismiss the misdemeanor charge after his office found a lack of evidence to continue the case. The office determined that there were no intoxicating substances in the defendant's breath or blood during the June 25th traffic stop. Court records reflected the dismissal Tuesday. Johnson was arrested during the traffic stop and booked into the Harris County Jail. She returned to court with sporadic attendance, ultimately going on medical leave from the 178th District Court for weeks. She is unopposed on the November ballot, ensuring she will serve a third time. Well, fuck you, you idiot, moronic Republicans of Harris County. This is what I tell you, okay? The political parties are full of shit. They didn't even put up a challenger to her. That's how sorry the Republican Party is. That's why when y'all like get all in the Trump bandwagon, oh, Republican, MAGA, MAGA, MAGA. I'm like, bullshit. Why? Why do you say that, Floyd? How do you know? Well, Sheila Jackson Lee, the late dumb as a box of rocks congresswoman from the 18th District of Texas, my district, I wanted to run against her. Okay, why? Because nobody else will. Somebody's got to stand up and be a fucking leader around here. There's too many cowards in this community. Nobody wants to be fearless. So I went and found out who ran against her in the last election. And god damn was I shocked. I went and looked up Carmen. What the fuck? How does a former 1984 Miss Venezuela, 1985 Miss Universe lose to Sheila Jackson Lee? Huh. Curious minds want to know, huh, Floyd? So, guess what Fearless Floyd did? I went and got my phone and I called Carmen. And I asked Carmen, hey, how in the hell did you lose to Sheila Jackson Lee? Well, Floyd, you're not going to believe this. Well, try me. Then Speaker of the House, Kevin McCarthy, a Republican, came to Harris County and withdrew all Republican National Committee funding for every MAGA candidate in Harris County, Texas, and supported the Democrats. Are you awake now? Are you on my level? Okay, because I don't care if they're Democrat, Republican, MAGA, Tim Walsh, horse semen guzzler. I don't care. Okay, I hold you accountable for your actions and words. I could care less what party you're affiliated with. I don't care what your dogma is. You're either right or wrong, good or evil, moral or immoral, unethical or ethical. There are no gray areas in between those two. But they seem to want to run around in the gray areas and expect us to believe that. So that's why I have a real big issue with the whole Republican, this whole Trump train, the whole MAGA thing, all these white hats in the background working for us. No, I'm not going for the okie doke. Okay. If you haven't looked in the mirror and you don't have your white hat on, then you're not a white hat. If you're looking around and guess what? You don't see anybody else wearing a white hat. Guess what? There are no fucking white hats. Y'all get off this bullshit. This is a joke. Okay? This is a corporation with subsidiaries that tentacle down from Washington, D.C. into the ether of our local communities. They're all parasites. How do they survive? Fines, fees, and taxes. How do they get there? Corruption and fraud. And I'm going to show you. And I'm going to lay this out. I don't care who I offend, because I'm a little pissed off. Because I had to go do 14 years and 2 months for a DWI that they never proved I committed during my bifurcated trial, my case in chief. 110%. And I'm going to show you all the fucking evidence. I'm going to go show you the case law to back it up. I'm going to show you my writ of certiorari to the United States Supreme Court, where I address all this. We're going to go over all this with a fine-tooth comb. And when I get done, you're going to be like, man, Floyd got fucked. Yeah. That's why I have now it's a $10,000 cash reward to anybody who can prove that I committed a third-degree felony pursuant to the laws in effect as of January 10th, 2020 or 2001. I'm not sorry, not January 10th. That was another felony. July 10th, 2020 or 2001. Sorry, July 10th, 2001. Absolutely. And we'll go through all that. So that's my deal on the Republican Party. They are fucking trash. Here in Harris County, trash, garbage. Whoever's the Harris County Republican committee leader, y'all need to take that guy out back to the woodshed and tar and feather that dude and run him through Main Street. He's a piece of shit. That's what I'm going to tell you. So, two sides of the same coin, right? Tritico attributed the injury to an incident in February of 2024 when Johnson, while riding a scooter at her home, fell and hit her head. He said she lost consciousness for several hours and woke up in a hospital after someone found her. She received 14 stitches, he said. Neurosurgeon experts warned that slipping unconscious in a fall like what Johnson is said to have experienced may be indicative of a serious brain injury that requires time and therapy to heal. Okay? So, while she was in the fucking hospital, right? Okay? Lost consciousness. So, you know they did CAT scans on her. They probably did an MRI on her because of her head injury. And they didn't tell her what? What? Requires time and therapy to heal. You don't think they told her that before they discharged her? Of course they did. But what did Kelli Johnson continue to do? Ride the fucking bitch. Like a winch. Absolutely. She went through a very complex retrial. Very complex. To the fact that she said she had nightmares regarding what she witnessed during that trial that happened when? After February 2024. She's a lying little. Yeah, she's lying. Her attorney's lying. Their lips are moving. Okay? Neurosurgeon, I already went through that. Younger adults tend to recover more quickly than others, which means she's about 50-something, so it's going to take her quite a while to recover. What can I do for you? Yeah. Boy, these telemarketers are just pounding me. All right. So let's do another quote. You don't have to have a high velocity or high height fall to suffer a traumatic brain injury, said Dr. Ganesh Rao, professor and chair of neurology or neurosurgery at Baylor College of Medicine. He explained that some patients don't behave like themselves immediately after, while others also struggle to concentrate at work and are unable to keep track of time or other memories. They might not recognize that their behavior is odd, he said. Tritico declined to elaborate on Johnson's diagnosis. Of course, that violates HIPAA. Absolutely. This is such a farce, folks. Is there a HIPAA release so somebody can announce that she has a brain injury? Otherwise, you're releasing personal medical information in the public. That's a violation of HIPAA. Are you following me? Are you seeing the corruption? Are you seeing the fraud? Thank you. Thought you would. Thought you did. Thought I explained this very carefully. Tritico declined to elaborate on Johnson's diagnosis, but said she continues to receive treatment for the injury and that it has so far been successful. I can't frickin' tell. She went and sat through a complex retrial with a head injury. that she knew she had, that she was instructed, all of this. You don't think these neurosurgeons, because of liability and indemnification, that they didn't give her all these warnings? Absolutely they did. Why? Because if she went out and her 2 law enforcement encounters for intoxicated related probable cause stops, if she would have ran over somebody, guess who would have been liable? Those doctors who released her without giving her a warning about her future potential behaviors due to her traumatic brain injury. Are you seeing how this works, folks? Are you seeing through the lies? Are you reading between the lines? Because I can. She sounds like Kelli Johnson I've known for years, he said. Johnson was pulled over by Harris County Sheriff's Office deputies for erratic driving in April during the thick of a high-profile bench trial. Did you hear that? February, she had the injury. April, she's in the middle of a bench trial. So apparently her head injuries weren't that bad. She could sit through and adjudicate a complex retrial. Okay, not a trial, a retrial. And if you don't understand the complexities of a retrial, it's a whole different animal, because you have these prior trials. Some of that information can't come into the new trial, the retrial. So the judge is the arbitrator of what can be allowed in and what can't be in. So this is a very complex trial. They have to know what the reporter's record and what the clerk's record, the trial record, because the record's the only thing that matters in those previous trials. Yes, you have to be very knowledgeable. You have to do your research. You have to actually fucking read. A sergeant in that traffic stop suspected Johnson of being intoxicated, and this happened right down from my house off 290 out past Jersey Village in Cypress. But she did not meet the threshold required for an arrest. Oh, yes, she did. Absolutely, she did. She started tossing out names, name dropping. We can call the sheriff, Ed Gonzalez. I'm going to lose my career over this if you arrest me. That's what she said on camera to the sergeant who was with the Harris County Sheriff's Deputy's Office, who let her skate. And he better get on his knees with his Bible and thank God every minute of every day that she did not go kill somebody after he released her. Yeah. Are you seeing everything? We're going to keep going. During the traffic stop, Johnson openly discussed her role in the trial of Brian Coulter, convicted of beating his girlfriend's child to death, according to audio from the body-worn camera footage of the encounter. Prior to Johnson's latest medical leave, top judicial leaders in Harris County effectively removed hundreds of pending cases from her docket. The decision to reassign Johnson's cases stripped her of the ability to preside over her docket without the State Commission on Judicial Conduct having to suspend her. You see how they protect their own? She's incapable of being a judge. She should be pulled off the fucking ballot this November. Hello? Yes. Yes. Okay. Okay. Can I call you after I do my live? Uh-huh. Oh. Oh, you're welcome. I'm not done. Oh. Well, if you live in Fort Bend County, come watch my show I'm doing right now on YouTube. It's about Kelli Johnson, 178th Judicial District Judge of Harris County, Texas. Absolutely. Yep. Oh, awesome. Oh, yeah. Absolutely. Right. Yep. Hey, man, let me call you back, George. I got my audience waiting. I will. I will. Thank you, brother. Okay. Bye-bye. All right. That was a local viewer from here, Fort Bend County, the next county over, Sugar Land, Texas, Richmond, Rosenberg. So the decision followed days where Johnson remained in her chambers and did not preside in her court. She also disparaged other jurors in late night text messages to a Chronicle reporter. In the meantime, see, Harris County voters are going to go vote this criminal back into office. That's all I can say. This is criminal behavior all the way around. Everybody involved in this is criminal. Her attorney's criminal. She's criminal. Brett Lejean, the Montgomery County District Attorney, he's criminal. The State Commission on Judicial Conduct is criminal. Y'all should have pulled her freaking license and put her off the bench. Y'all should have suspended her until she could take a cognitive exam to be put back on the bench due to her traumatic brain injury that she failed to protect the citizens of Harris County from her erratic behavior, which she was admonished to in the hospital by those neurosurgeons before she was released. In the meantime, Johnson's court reporter also lodged a complaint with the commission over concerns of a hostile work environment the judge allegedly caused. The judge's spouse briefly sought a temporary restraining order against her that was dismissed, according to court records. Oh, is your home life bad, Kelly? Because I asked you to contact me because I was going to take you to an AA meeting at the Post Oak Club over on Long Point so you could interact with Hall of Famers from the NBA, Major League Baseball, gold medalist Olympian, and a bunch of other movers and shakers. Very powerful people. But nope, you didn't take me up on offer. You decided to continue your criminal enterprise because that's what you're doing. The sheriff's office also investigated damage to Johnson's courtroom. Photos reviewed by the Chronicle show toppled chairs, a smashed printer, woman's shoes, and various papers and clipboards scattered throughout the well, an area where lawyers often congregate to address a judge. The images taken the afternoon of July 19th by someone standing at the judge's bench also showed, wow, that's illegal, taking pictures in the courthouse? Oh my God. If that was Sean from Long Island Audits, y'all would fucking have him sitting in the Harris County Jail, wouldn't you? The images taken the afternoon of July 19th by someone standing at the judge's bench also showed two bailiffs, the court's clerk, and pretrial services staffer present in the courtroom. Pretrial services, that's your court liaison between the probation office. Here's your court clerk and two fucking Harris County Sheriff's deputies who are complicit. You're all complicit. And here is the illustrious Kelli Johnson. She goes to her docket on Friday, July 19th, 2024. So do you think somebody with a traumatic head injury that's going through rehabilitation and therapy should be sitting on a bench adjudicating the livelihoods of potential criminal offenders? This is what's going on in Harris County, Texas. This is what's going on nationwide. This is bullshit, folks. This fucking sucks. Because the entity that's supposed to be holding these people accountable, this guy, obviously, he's a fucking corrupt criminal. This entity, where the hell they at? State Commission on Judicial Conduct. What a fucking joke they are. Boom. Now, these are all Governor Greg Abbott appointed officials. All these commissioners that sit on all these state commissions are all appointed by the governor. So where does the buck stop? at the CEO's desk. Who's the CEO? Greg fucking Abbott. Are you seeing the bigger overall picture? And most people would think, if you're actually thinking, that, goddamn, Floyd, you're doing something that's detrimental to your own freedom, your own cause. Absolutely. Why? I don't hold back. I don't pull punches. If you're corrupt, you're corrupt. If you're fraudulent, you're fraudulent. If you're unethical, you're unethical. If I can prove it and show it, yeah. Greg Abbott let the border of the state of Texas be open. He decided he wanted to have a sanctuary state without saying it. He's allowed these illegal immigrants to waltz right in the fucking front door of every Texas Department of Public Safety office and go get a driver's license and or a Texas ID. Why? Because they monetize those contracts and applications. Fuck yeah. Oh, we could use a bonus of another 10 million people. And then we got another 10 million more moving here from all these blue states and cities and counties and parishes. So we got all kind of revenue coming in the state of Texas. No wonder they had $60+ billion in surplus the last legislative session. And they were all like fumbling around going, where the hell should we spend $60 billion? Well, if you would have listened to Fearless Floyd, you would have hired a fucking army and sent them to the goddamn border to protect us. But no, you didn't do that. You waited 3 years later, and then, Greg Abbott, you decided you wanted to send some troops down to the border and build them a little base. After millions of serial career criminals flooded into Texas. And then you bust them to other states instead of busting them back to Mexico or Venezuela or Honduras, El Salvador, Guatemala, or wherever else the fuck they came from, you moron. Yeah, I'm a little pissed off at my state. I'm pissed off at my corrupt corporate government. Absolutely. And I'm calling them out. And I've called them all out to their face. That's why I got the name Fearless in prison, because I used to call out my wardens, assistant wardens, the directors, regional directors. I didn't give a fuck who they were. They're people just like me. They wake up, put on their clothes, just like me. They are no different. But are they going to act with faith and honor and clean hands? Or are they going to be a corrupt soul? Because that's what's happening. So we're going to dive into the next one. Let me stop share, make sure that it's sharing. DWI charge against Harris County Judge Kelli Johnson dismissed as she recovers from brain injury. Johnson had a bad fall in February and hit her head on the pavement. When she woke up in the hospital, she had no recollection of how long she had laid in the roadway, her attorney said. Kelli Johnson speaks to the jury during the trial of Terry Thompson, who was accused of fatally choking John Hernandez, shown Wednesday, June 13, 2008. After recovering from a brain injury, because she has not recovered, Harris County Judge Kelli Johnson will reassume her judicial duties after a charge accusing the driving while intoxicated was dismissed. So they're claiming, oh, it's insufficient evidence. Well, I'm going to get right into this, and I'm going to show you that there was 110% sufficient evidence to charge, try, convict, and sentence Kelli Johnson to a misdemeanor DWI. She should have been taken into custody for her original first traffic stop right down the freeway from me. Her other one was right over here in Spring Branch off Hempstead Highway. So she obviously lives around here somewhere. She is being treated for a medical condition that she will recover from. Okay. She's not recovered. Once she is completely recovered, she'll be able to resume her duties. She will not do so until she's completely cleared and ready. I can't tell. She was back on the bench when? In July. So we have somebody that's got a brain injury. They're not 100% cognitive. That person is sitting on the bench, adjudicating, holding the lives of the accused, the victims, in a brain that doesn't function 100%. Is that fair and just? Does that meet the definition of due process? Absolutely fucking not. This is a crime. You're witnessing a crime right in front of your eyes. Multiple crimes. Nobody will hold anybody accountable in the government. This is the problem that we're having. Our governments are corrupt on all levels. Local, city, town, county, parish, state, federal government. They're all corrupt. There's a few of the law enforcement and the judiciary that are waking up and realizing, oh my God, I've been committing fraud. I've been corrupt. I'm a criminal of all the things I've been doing for the what? The corporation. I've been running a for-profit corporation courtroom, not a common law, equitable chancery court. Most attorneys, licensed bar attorneys, and judges, former judges and justices, they're sociopaths. They have no empathy for anybody. If Kelli Johnson had any kind of integrity, she would have taken a leave of absence in February. But she didn't. So, do you think she lost her mental faculties? Possibly. So when she was driving, do you think she lost her physical faculties because her driving was erratic enough to cause a probable cause stop for potential intoxication? Are you reading the writing on the wall, folks? Court documents assert no drugs or alcohol were detected in her system the night she was pulled over for driving under the speed limit by a Harris County patrol supervisor who smelled what he thought was an alcoholic beverage on her breath. Let me tell you something, folks. My case, my DWI, no standardized field sobriety test, FFSTs, none, zero, refused, all. It's a scene that's in the police report by Christopher Green. A fired, terminated Houston Police Department officer. Oh yeah, he was terminated. Why? He pulled over another DWI suspect over in Westheimer, who apparently was probably a stripper or a prostitute, I don't know, but apparently she had a bunch of naked pictures on her phone. He downloaded her pictures on her phone to his phone, and then when they went to court, he was showing court personnel her naked pictures. That's my arresting officer, Christopher W. Green. And he's probably still in law enforcement for some other police force or constable or sheriff's department. Because that's how they roll. They protect their own. She was released after a sobriety test determined she was not under the influence. Months after the incident, she was arrested on the DWI charge. Okay, sobriety test. There are 3 types of standardized field sobriety tests. One leg stand, walk and turn, horizontal gaze nystagmus test. Hang on. And that's Jesse calling me. She has not sent an address. Yep. Thanks. Bye. All right. I have to send a book to to Janine by Tarot by Janine. Anne's going to be on her show. So I'm trying to get her a trust book. All right. She was released after a sobriety test. Okay. Those are the 3 standardized field sobriety tests by the National Highway Transportation Safety Administration. If you'd like to see the book, I have it right here behind me. I'm an expert in DWIs, standardized field sobriety test, breathalyzer or intoxicated 5000, which is the breath test. And then there's the blood test. So pursuant to Texas state law, you can be convicted of a driving while intoxicated offense if you have a BAC of 0.08 or greater, right? That's blood and alcohol content. Or there's a detection of drugs, which can be illegal or prescribed, even over the counter. Or, there's something else, Floyd? Having lost your mental and or physical faculties by introduction of an intoxicating or adulterating substance of alcohol, drugs, or another unknown substance. And we'll get into all that. There was, quite frankly, no probable cause to arrest her, Tritico said Tuesday. We are relieved that the truth has come to light and look forward to Judge Johnson returning to her duties after recovering from a brain injury. Johnson has presided over high-profile cases, including the murder trial of Antonio A.J. Armstrong Jr., who was last year convicted of killing his parents in 2016. We're going to move on to the next one. And I found this extremely odd. I don't know if it's true, but, I'm going to show it to you. And I found it just like, wow. Are there really any coincidences? Are there really any coincidences? Mothering after brain injury. Kelli Johnson, with an I, Kelli Johnson's story. Mothering is challenging for anyone. Mothering through and following traumatic brain injury can be even harder. This is by Craig Hospital, of all names. I swear you can't make this stuff up. It's crazy. All right. Mothering is challenging for anyone. Mothering through or following a traumatic brain injury can be even harder. Kelli Johnson is no stranger to these challenges. In 2011, Craig, graduate from Wyoming, was the mother of 3 young children when she sustained traumatic brain injury in a skiing accident. Okay. And this just goes on and on and on and on and on. Well, what I found funny was, let me back that up. Okay. Let me do this. All right. Yeah. Make sure I'm over here still sharing. All right. Kelli Johnson brain injury. And you just put this in Google. And here, Judge Kelli Johnson's DWI charge dismissed after brain injury. Charges dismissed. And then you go right here to Craig Hospital. Mothering after brain injury. Kelli Johnson's story. I was like, huh? And it's a different Kelli Johnson with a brain injury. You see what I'm saying? Is that a coincidence? Did she Google this and go, oh, well, hey, maybe I should use the brain injury. There it is. There's my defense. Brain injury. I don't know. I thought that was like highly coincidental. And here's some more. Yeah, that's the same article. Now, let's get into some good, better stuff. So we've got the local news. This one, Rachel Bowman. This is from the Daily Mail, UK. So we had to go across the pond to get some real information. Mystery as high-flying Texas judge vanishes from courtroom for weeks after presiding over state's biggest trials. Rachel Bowman. Kelli Johnson has been absent from the courtroom since May 1st. A May 4th police report cited her involvement in calls for a crisis intervention. Courthouse employees said she exhibited manic behavior and is a danger. Warning, Will Robinson, danger. But apparently the Texas Commission on Judicial Conduct doesn't care. The Montgomery County, Texas District Attorney Brett Lejon does not care. They're criminals, all of them. They are aiding and abetting a criminal committing criminal offenses. I can go address them. I'll get them. Okay? This is fraud and corruption at its highest level that you're ever going to see. A prominent Texas judge has been missing from the courtroom after presiding some of the state's biggest trials, prompting concerns over her well-being, according to reports. Judge Kelli Johnson has been absent from the 178th District Court since May 1st, reported KTRK, which is our local ABC affiliate. Now, do I have experience in the 178th District Court? Absolutely. I was convicted of a possession with the intent to distribute and manufacture cocaine less than 454 grams, and it was actually 112 grams rock that I sold to Bob, then HPD undercover narcotics officer. I told you I'll tell you all the truth. Johnson oversaw several of the state's major trials and convicted a man of capital murder for the 2020 beating death of an 8-year-old boy in April. February, I have my head injury. April, I'm going to go sit over a capital murder trial for the beating death of an 8-year-old boy. Her absence led to the speculation about her mental health, with one courtroom employee telling a local news station she exhibited manic behavior. She's a danger to herself and to the community, the employee said. Wow. Last time I heard that, that was the former 351st Judicial District Judge, Mark Kent Ellis, telling me that I was a danger to the citizens of Harris County, Texas, and therefore I was going to be sentenced to a term of not less than 60 years in the Texas Department of Criminal Justice Correctional Institution Division. Sheriff, remand the defendant into custody. Have a nice day, Mr. Tarvin. So here's our illustrious Kelli Johnson. Here's her family. That apparently these two are having trouble. Okay. Sorry about that. Well, I didn't know it was going to do all that, but all right. An officer decided, okay. A Houston police report obtained by KTRK revealed Johnson was involved in an incident near her home May 4th. Okay. Again, February, March, April, May. An officer cited disturbance, CIT, on the report, which is a police acronym for crisis intervention. Johnson's out for personal matters. She's the first openly gay female judge elected in Harris County and has 2 sons, a 12-year-old and a 10-month-old, and her wife, Hillary Bartlett, according to her biography. This is her sitting in the courtroom in April with a traumatic brain injury. So do you think she should be sitting here adjudicating, interacting with these people? And look at this clown over here. He's just as complicit. He's violating his oath of office, Sergeant. Here she is again. I don't know who these clowns are beside her. Here's a judge sitting in for her, Jim Wallace. No saint himself. Johnson previously served as an assistant district attorney for 17 years and got her law degree from the South Texas College of Law, which pretty much just hands out those fucking degrees like goddamn toilet paper at a toilet paper rally. How do I know? I've read the appellate briefs of these court-appointed appeal attorneys, and we're going to go into mine. And I'm going to show you what a partner at one of the most prestigious DWI law firms in Harris County, if not Texas, did in my case. His name was Tom Moran. He's Tom Moron, because he filed my appellate brief on grounds that the United States Supreme Court had just adjudicated a couple months earlier. I'm like, what the fuck are you doing, you idiot? Why are you presenting an appeal brief that's already been adjudicated by the highest court in the land? This ain't going nowhere. And it went nowhere. Meanwhile, I'm pulling up all these fucking errors because now I'm in the law library studying, learning when I should have from the very get-go. But I decided I want to put all my faith in the judicial system. And I got fucked. I'm still getting fucked. As a judge, she serves as the administrative judge over the criminal board and is on the state board, state of Texas board of the Texas Association of Specialty Courts. So, do you think somebody with a fucking traumatic brain injury who's acted erratic, had a crisis intervention called to her home, 2 law enforcement encounters, 1 arrest for DWI, should have been 2, do you think she should be still holding these titles and positions? Is this not corruption and fraud? In April, after 20 minutes of deliberation by the jury, Brian Coulter, 34, was found guilty of capital murder, capital murder trial that she just sat through, for beating his girlfriend's 8-year-old son, Kendrick Lee, to death in 2020, leading to Johnson sentencing him to life in prison. She spared him from death row. This is probably one of the most horrific set of facts that I've ever had to witness, to listen to, and to imagine, Johnson said during her sentencing. Well, you probably should have took a leave of absence when you fucking got out of the hospital, you dumbass, you corrupt criminal. Sir, those children have haunted me this last week. I hope, sir, that when you're in prison, those same boys that have haunted my mind haunt yours. Coulter will serve life in prison for beating the child to death inside the couple's apartment at City Park 2 complex in Houston, November 20th, 2020. And this is him. We're not going to watch the videos. This is the other one, AJ Armstrong. I'm not going to go into all the minutia of this. You can read it for yourself. So let's go do some reading, Floyd. Okay. Well, I should have had, but I don't. Let me go whip it up. What I have here, folks, is Texas Penal Code 4904, driving while intoxicated. Person commits an offense if the person is intoxicated, okay? We're going to go into this. While operating a motor vehicle in a public place, except as provided by subsections C and D of Section 4909, which we will get into here in a second, which is enhanced penalties, offenses and penalties for a repeat habitual DWI offender. If it is shown on the trial of an offense under this section that at the time of the offense, the person operating the motor vehicle had an open container, adds a little bit more. If it's shown on the trial of an offense under this section that the analysis of the specimen of the person's blood, breath, or urine showed an alcohol concentration level of 0.015 or more at the time of the analysis was performed, as an offense It's a Class A misdemeanor. Okay. So let's go over here, Floyd. Oops, wrong one. Enhanced Offenses and Penalties, Section 4909. A. We're going to get down to D. D's where the nitty gritty comes in, but we're going to go through all this. Except as provided by subsection B, an offense under section 4904, driving while intoxicated, or flying while intoxicated, boating while intoxicated, assembling or operating an amusement ride while intoxicated. Okay. It's a Class A misdemeanor with a minimum term of confinement 30 days if it is shown on the trial of the offense the person has previously convicted one time of an offense relating to the operation of a motor vehicle while intoxicated, an offense operating while aircraft, operating with watercraft while intoxicated, or offense of operating or assembling an amusement ride while intoxicated. An offense under section 4904 and all these other ones is a felony of the third degree if it is shown on the trial of the offense that the person has previously been convicted. All right, you ready? Okay, this is all these little elements. Okay, what does that say? Elements. We're going to get into this. One time of an offense under 4908, intoxication manslaughter, or an offense under the laws of another state of the offense contains elements that are substantially similar to the elements of the offense under section 4908. Two times of any other offense relating to the operating of a motor vehicle while intoxicated, aircraft, watercraft, assembling an amusement ride. Okay, here is B1 and 2. An offense under section 4909, intoxicated assault, is a felony of the second degree if it is shown on the trial of the offense that the person caused serious bodily injury to a firefighter or emergency medical personnel while in the actual discharge of an official duty, or a felony of the first degree if it is shown on the trial of the offense that the person caused serious bodily injury to a peace officer or a judge while the officer or judge was in the actual discharge of an official duty. Okay. An offense under section 4908, intoxication manslaughter, is a felony of the first degree if it's shown on the trial of an offense that a person caused the death of a person described in subsection B1, which is this one. So we can keep going on what a firefighter means, what emergency medical services personnel. Okay. B4, offense under this section 4907, felony, C, offense relating to the operation of a motor vehicle or operating of a motor vehicle while intoxicated means an offense under section 4904, an offense under section 4907, an offense under article 6701L-1 revised statutes that the law existed before September 1st, 1994. This is the Texas Transportation Code, Article 6701L1. That's what they're talking about. And when I tell you guys, and you will see in the upcoming video tonight at 7:30, when I talk about Scam Anderson, I will address this, okay, of how this works. This is when John Whitmire, who was in the Texas Senate and over the Texas Criminal Justice Committee, he was the chair of that committee, they rewrote the penal code. They moved this from the transportation code into the penal code and put it under 4909. That's what that's talking about. So if you have a DWI conviction prior to this date, it still applies. If you have one prior to that date, it still applies. Criminally negligent homicide, an offense under other laws of another state that prohibit the operation of a motor vehicle while intoxicated. Number 2, offense of operating an aircraft while intoxicated. We don't need to do that. Offense of watercraft. Don't need to do that. Offense of operating assembling amusement ride. Don't need that. Here we go. Here's D, folks. Okay. They have fucked around with this section for decades. For the purposes of this section, a conviction for an offense under 4904 and all these other ones that occurs on or after September 1st, 1994, okay, is a final conviction, whether the sentence for the conviction is imposed or probated. E, repealed in 2005, effective September 1st, 2005. Okay, now let's look at these dates. September 1st, 1994 to September 1st, 2005. But this was repealed ending August 31st, the day before September 1st of 2005. So this is the heyday of Mothers Against Drunk Driving, MADD. They started in the late 90s and kind of phased out in the early 2000s. So what they were doing is they were tinkering with this section, trying to get more repeat DWI offenders off the streets. So they kept changing up all the elements of the offense. But the problem is that the Texas County and District Attorneys Association, okay, the Texas County and District Attorneys Association, who creates all the books for all the district attorneys and counties attorneys across the state of Texas, used a boilerplate charging instrument and indictment for all felony DWIs. The problem is they never updated it as the law changed and the elements of the offense changed. So every felony DWI conviction in the state of Texas from September 1st, 1994 to August 31st, 2005 are null and void. They are not felony convictions because the court or the prosecution did not allege in the complaint or indictment, prove to the jury or trier in fact all the elements required to get a conviction for a third-degree felony DWI in the state of Texas. Yes, I said that. I'm going to prove it. How do I know this? You know how many felony indictments for DWI I've read that weren't mine? Dozens. Probably 30 to 100. Because everybody who hit the win unit and had a DWI or intoxicated related offense, guess who they came and talked to? Moi. Well, let me read your record. Oh yeah, this isn't a felony conviction. They didn't allege the elements as they are stated. So I'm going to show you fraud and corruption. And sadly, because look, I don't advocate driving while intoxicated or operating an amusement ride or assembling an amusement ride or boating or watercraft, none of that, okay? I'm 100% against driving while intoxicated. I don't drink. I have 22 years sobriety. Thank God, May 10th. And in this day and age with Uber and Lyft and all the other modes of transportation that are available, nobody should be behind the wheel intoxicated driving. End of story. I'm guilty of it, and I think I've done my time. But I'm going to prove to you right now, I'm going to show you everything that you need to see to prove, okay, that for what, 11 years? 11 years of felony convictions for DWI, and that's about probably 70,000 convictions. All of them. Null and void. Every one of them. Because not one indictment is pled correctly. Now, if you went in and plea bargained and accepted that, well, your ass is grass. I took mine to trial and lost. Why? Because I had a fucking incompetent attorney, J.T. Wilhite, who is now disbarred. Are you seeing a pattern in my case? I got a terminated arresting officer. I've got a disbarred attorney. Oh, yeah. We're going to get into more of this. This is why I tell you, folks, I've experienced the corruption and fraud, firsthand experiences, just countless fucking times. Countless. And nobody will hold anybody else accountable. Our fucking state government here in Texas is corrupt. All of them. I don't give a fuck who they are. All the way to Greg Abbott, all the way to the fucking Texas Supreme Court, Court of Criminal Appeals, all 14 courts of appeals, all district courts in the state of Texas, all judiciary courts in the state of Texas are for-profit corporations. And I'm going to show you their Dun & Bradstreet background business report proving that 110%. Absolutely. So as we scroll down, we get into G. A conviction may be used for purposes of enhancement under this section or enhancement under subchapter D, classification of offenses outside this code, or chapter 12, punishments, but not under both this section and subchapter D. For purposes of this section, a person is considered to have been convicted of an offense under 4904 or all these other ones if the person was placed on deferred adjudication, mini supervision for the offense, blah, blah, blah. Okay? So basically, what they're trying to tell you, okay, is that classifications of offense under subsection D, chapter 12, punishments. What they're getting into is that a conviction may be used for purposes of enhancement under this section or enhancement under subsection D, but not under both this section and subchapter D. So what is section 1242D, Floyd? See how I spit that right out? 1242D is enhancement punishments for repeat habitual felony offenders. Damn, Floyd, what's 1242B? B as in boy. Oh, that's repeat habitual misdemeanor offenders. Huh. So if they don't prove all the elements of a third-degree felony DWI in the primary case, and they use two other misdemeanor and felony or misdemeanor DWIs to enhance that offense to a felony so that they can go back and get two more felonies under 1242D, but yet they failed to allege all the elements of a third-degree felony, which makes it a misdemeanor. So under 1242B's and boy, okay, you're a repeat habitual misdemeanor offender, which you can be repeatedly convicted of misdemeanors and felonies. But your primary offense needs to be a felony to get you under 1242D as in dog. I told you, I know this stuff. I lived and breathed it for 12 years. And I can't tell you how heartbroken I was when I realized that the state, the great state of Texas that I love, that I call myself a Texan, that I'm proud of, is fucking corrupt. They are sinister. They are evil. They are satanic. I'm calling them all out because I'm going to show you the depravity of what these fucking idiots will do so they can come up, so they can get those bonds, so they can go sit at the water cooler and talk about how many years they gave out this year. Oh, I'm at 3,000 years and 6 life sentences and 1 death penalty. That's something to brag about. You're destroying lives. You're destroying families. And you don't care about the due process or due course of law. Because if you go look up the definition of due course of law or due process, because it's a prosecutor's duty to seek fairness over a conviction. But what do? They make you go in there and prove you're innocent. Wow, is that skewed? Do you see how they've turned the whole system upside down on us? I'm just one lonely voice out here in the ether screaming my head off. And nobody's listening. Nobody will hold anybody accountable. Nobody gives a fuck. They don't care that their integrity, honor, good faith is all horseshit. These people are evil, corrupt criminals. And we're going to continue to go through this. They've added all this. It just used to stop at D. It said D and E, and I think it added an F. And then all this, they've been added over time. Okay. And we can get into all this, but none of this applies to me. This is all new shit. Ding, 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 ding. You see how many times they've amended this? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 times. Okay? 11 times. That was before 2005. They amended it again in 2001. They amended it again in 2003. It's not on here. Let's see if there's on. There's your 2003. There's your 2001. You don't think I know what the fuck I'm talking about? I went to the Texas Legislative Library and I got all this. Absolutely, I did. I did my homework. I did my research. I know where to go. I know what to do. And I did it. And I have all this evidence. Now, let's see. Yeah, we already did that. All right, this is Weaver, which one was done first? Weaver. Let me get a date. That's 01. I'm pretty sure this is part 2. Yep, September 1st, September 11th, 2002. Ha! Is that a coincidence? I don't know. We're just going to dive into Weaver real quick because I want to show you guys some stuff. This is Stephen Lewis Weaver versus Texas Court of Criminal Appeals. Here's the number. This is on the PDR. This is on the state's petition for discretionary review from the 6th Court of Appeals of Harris County. There are no 6th Court of Appeals in Harris County. There's the 1st and the 14th. The 6th, I believe, is, I want to say Dallas, maybe Corpus. I don't know. I have to go look. Texas Penal Code sections, that's what that means, sections 4904 and 490B define felony driving while intoxicated as a DWI plus 2 prior intoxicated-related convictions. For purposes of proving a felony DWI, Texas Penal Code 4909E bars the state from using an intoxicated-related convictions that are more than 10 years older than the instant offense. That's called remote convictions. Unless, okay, here's the caveat, the linchpin, the ultimate element of the offense. There exists another intoxicated-related conviction within 10 years, okay? A conviction. I want y'all to pay attention to these words because they matter. Conviction within 10 years of the instant offense, which is a primary offense, that's called the intervening conviction. So let me give you a diagram. I have a 2001 DWI. That's my primary DWI that I'm being tried for. They went back and they got another one from 1994. Then they went back to 1986, 87 conviction, 86 charge, and used that. Okay. My offense date of my arrest was July 10th, 2001. So I fall under the law from when? September 1st, 2001 to August 31st, 2003. Remember, I told you they amended it in 2001. They amended it again in 2003. So I have that 2-year window of the application of the law in effect at the time of my offense to apply to me for my elements of my offense. Do you understand that? So we're going to get into this. Listen to the words, okay? These words are very specific in their meaning and their holding and their precedent. The 6th Circuit Court of Appeals held, okay? This is all that matters. What did they hold? Their holding is what is precedent. That where the two prior convictions alleged in the indictment are remote, the state must, mandatory language, must submit evidence of an intervening conviction to the jury, and that without such evidence, the state did what? Failed to prove an essential element of felony driving while intoxicated. Weaver, 56 Southwest 3rd, out of Texarkana. This issue in this case, whether the Sixth Court erred, we hold that it did. The relevant facts. On July 24th, 2000, okay? So he's going to come under the previous law from September 1st, 1994 to August 31st, 2001, because the date of his offense is when? July 24th, 2000. Okay, so he's going to come under the statute as it was prior to its amendment, September 1st, 2001, which is me. And I'll get into the next case, Getz versus State, which addresses my case 100%. Okay, so Weaver, felony the indictment alleged that the appellant was driving while intoxicated June 24th, 2000. And that he had previously been convicted of the same offense on August 10th, 1990, and January 17th, 1984. Those prior offenses were actually committed, okay? Now, I want you to see this right here. Committed, okay? Not convicted, committed on May 2nd, 1990, and November 23rd, 1983, respectively. Appellant entered a plea of not guilty, and the case was tried before a jury. At the trial, during the state's presentation of its case in chief, appellant objected to the admission of the prior DWI convictions alleged in the indictment. The trial court held a hearing. That would be a findings of fact, conclusions of the law. It's called an evidentiary hearing on the matter outside the presence of the jury. Appellant argued that pursuant to Texas Penal Code Section 4909E, the state must allege in the indictment and prove at the trial at least one of the prior DWI convictions was used to enhance the offense from a misdemeanor to a felony occurred, which means it was committed, not convicted, committed within 10 years of the instant offense. Appellant argued further that since prior DWIs alleged in the indictment occurred more than 10 years before the instant offense, they were inadmissible for enhancement purposes. In response, the state explained that in order to comply with 4909E, it planned to introduce evidence of an intervening conviction outside the presence of the jury. Okay? Not a commission, conviction. The state then presented the court outside the presence of the jury evidence that the appellant was convicted of a DWI on February 17th, 1997, which is not alleged up here. The trial court then overruled the appellant's objection and denied his subsequent motion for an instructed verdict that was based on the same grounds of his objection. The jury later found the appellant guilty of felony DWI, assessed punishment and imprisonment at 39 years. Okay? This dude got fucked. He got a 9 on the end of his 30. That's a notice to the parole board. Hold this dude really accountable for his actions. Otherwise, they would have given him 40 years. A nice round number. This is a code for keep them there as long as possible. As you see, the excessive term, this is the Mothers Against Drunk Driving. On appeal, appellant reiterated his argument that the prior DWI convictions alleged in the indictment were inadmissible. The Sixth Court of Appeals agreed with appellant and held that the trial court erred in admitting evidence of the two prior DWI convictions alleged in the indictment. The Court of Appeals reasoned that unless one of the two convictions alleged in the indictment occurred within 10 years of the instant offense, the state has not met its burden of proof because it failed to prove an essential element of felony DWI. See also Rodriguez. And this is the holding right here in Rodriguez. That's what you see right here in the parentheses. An intervening conviction is an element of the offense. We granted state's PDR to determine whether the Court of Appeals erred. In its brief to this court, state contends about requiring blah, blah, blah. We've already gone through all that. Okay, let's get into the analysis. And I know all this case law. I've read every one of these cases you're fixing to hear. Up until, I would say, 2011, maybe 2010, I read every intoxicated related case citing in Texas or anywhere else I could read. So the elements of the offense must be charged in the instrument. Here we go with that mandatory language again. Submitted to the jury and proven by the state beyond a reasonable doubt. And that's Jones versus U.S. I believe that's out of Arizona. Here's Inouye Renship. These are all Supreme Court cases. In Texas, an element of the offense is defined as the forbidden conduct, required culpability, any required result, and the negation of any exception to the offense. Texas Penal Code sections 4904 and 4909B together define the offense of felony driving while intoxicated. Gibson versus State, where they explain the two prior intoxicated related offenses referred to in 4909B, whether they are felonies or misdemeanors, serve the purpose of establishing whether the instant offense, the primary offense, qualifies as felony DWI. The prior intoxicated related offenses are elements of the offense of the felony driving while intoxicated. They define the felony, offense of felony, and are admitted into evidence as part of the state's proof of its case in chief during the guilt and innocence stage of the trial. In other words, and I've read this too. In other words, under our penal statutes, two or more prior intoxicated related offenses are specific attendant circumstances that serve to define in part the forbidden conduct of the crime of felony DWI. Here's out of Lefebvre and Scott discussing the fact that the definitions of some offenses require the presence or absence of specific attendant circumstances. And this is where we're going to get to the essential elements, the commission dates, not the conviction dates. Thus, if a person such as appellant commits a DWI with the requisite attendant circumstances, i.e. two or more prior intoxicated related offense, and that person has committed a felony DWI, but it goes even deeper. At the time of the appellant's offense of 4909E, however, provided that a conviction may not be used for enhancement purpose under this section if the conviction was a final conviction under subsection D, which means a mandate was issued in the case, and I'll show you a mandate here in a minute, and was for an offense, what was it? Committed. What does that say? Committed. More than 10 years before the offense for which the person is being tried was committed, and the person has not been convicted of an offense under section 4904, 4905, or blah, 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 or any other offense related to operation of motor vehicle while intoxicated, committed within 10 years before the date on which the offense for the person was being tried. Okay? So, the Court of Criminal Appeals had to address these amendments by the Texas legislature. A little delayed, but they addressed them. Weaver is one of these predominant precedent cases. In some, well, here, let me dive over here. In order to charge a person with a felony DWI, the state must allege in the indictment that the defendant has been convicted of at least two prior intoxicated related offenses, whether they be felonies or misdemeanors. Where there are more than two prior convictions, the state should usually include in the indictment the two most recent convictions. However, if for some reason the state chooses not to allege the two most recent convictions in the indictment, and those two convictions are more than 10 years older than the instant offense, the state must comply with 4909E. Because section 4909E is not an element of the offense, the state need not allege the intervening conviction in the indictment or submit it to the jury. The state must, however, at some point during its case in chief, the guilt and innocence phase, submit proof of the intervening conviction to the trial court. Here, during its case in chief, the state offered evidence of an intervening conviction. A fingerprint identification expert testified in a hearing outside the presence of the jury that appellant's fingerprints matched those contained in a penitentiary pen packet for the February 17, 1997 DWI conviction. The trial court then, upon the state's request, admitted the penitentiary pen pack into the record. See, the trial court then, upon the state's request, okay, this is during trial, so the attorney never had a chance to address any of this. This procedure sufficiently complied with the requirements of 4909E. Therefore, the trial court did not err in allowing the state to admit into evidence the prior remote DWIs alleged in the indictment, and the Court of Appeals erred in holding otherwise. Accordingly, we reversed the judgment of the Court of Appeals and affirmed the judgment of the trial court. Delivered September 11, 2002. Publish. This means it got published and it retains precedent. This means that whatever attorney filed this, or if Weaver went pro se, but I'm pretty sure he had counsel that handled this for him, they are now a published litigator. Okay? Published. Now, we are going to get into something else. Are y'all ready? This is Getz versus State. Summary. Affirming appellate court's reformation of trial court's judgment in Anders case. PD, petition for discretionary review. There's a number. January 26, 2005. Okay, and I want you to look at this date, 2005, how long it took this guy to get relief. Appeal from the Judicial District Court, Henderson County. Nancy Paul Perkins, Athens for appellant. Getz. Matthew Paul, State's Attorney, Austin for the state. This was Justice Kiesler delivered the opinion for the court, in which Price, Womack, Johnson, Hervey, and Holcomb justices joined. Obviously, the presiding judge did not. Opinion. Bobby Dole Getz was charged with a DWI committed in 2002. Okay, so he falls in within the September 1st, 2001 through August 31st, 2003, like me. The indictment alleged two previous DWI convictions, one in 97, one in 84. We must decide whether these previous convictions were sufficient to elevate the 2002 offense to a third-degree felony. Based on the 2001 amendments to the DWI statute, we conclude that that answer is no. You want to repeat that? We must decide whether these previous convictions were sufficient to elevate the 2002 offense to a third-degree felony. Based on the 2001 amendments to the DWI statute, we can conclude the answer is no. Damn, Floyd. How come you can't get off that fucking 60-year sentence? Because of corruption and fraud. Facts and procedural history. Getz was charged by indictment with driving while intoxicated. The indictment further alleged, now remember, there's a difference between the complaint and the indictment. Although they do look similar, they are different. The indictment further alleged that prior to the commission of that offense, which is a primary offense, Getz had been, this is the 2002 offense they're talking about, okay? Getz had been convicted of a DWI on April 26, 1984. He'd been convicted, okay? And on September 11th, 1997. Boy, there sure are a bunch of September 11ths floating around here today on September 11th, aren't there? I told you, folks, divinity controls my life. How could I have all these coincidences happen on this one day when I had no idea what I was going to talk about today, who I was going to put on, if I was even going to have a guest, or I was going to call somebody and just do a live. So, in an enhancement paragraph, the indictment alleges that Getz had been previously convicted of a felon in possession of a firearm. Get's lawyer filed a pretrial motion to dismiss, arguing that the indictment failed to allege a felony DWI because the 1984 prior conviction occurred more than 10 years before the offense being charged in the case. Getz filed a pro se motion to quash the indictment on the same grounds. The trial court held a hearing and overruled Getz' motions. Getz then pleaded guilty pursuant to a plea bargain agreement for 3 years in the state's abandonment of the enhancement paragraph. Getz filed notice of appeal. His appointed counsel filed an Anders brief, and Getz filed a pro se appellate brief arguing that the trial court erred in denying the pretrial motion to dismiss and that the trial court lacked jurisdiction because this was not a felony DWI. The Court of Appeals agreed. It found that the 1984 conviction met each of the requirements for remoteness under Penal Code Section 4909E, and therefore was unavailable for enhancement. As a result, the appellate court reformed Getz' judgment to a Class B misdemeanor and remanded to the trial court for sentencing. Trial court denied the state's motion for rehearing, noting that the 4909E is unambiguous on its face. Here's Anders versus California. That's basically when you plea out guilty, but you're not taking responsibility for the case. Here's Getz, all the sightings. We granted the state's petition for discretionary review to decide whether the Court of Appeals correctly interpreted 4909E. Well, let's go look at a little analysis from the court. When discerning the meaning of a statute, we begin with its plain language, okay? Plain language. That is a legal term, folks. Our leading case in statutory interpretation, Boykin versus State, instructs us to first focus our attention on the literal text of the statute in question. For those of you who will be watching my video tonight on Scam Anderson, you're going to see some of this same vocabulary. Okay? So pay attention to what I'm saying if you're going to watch it tonight. If you have 3 hours to spare, I know it's lengthy, but I cover a ton of ground. And if you're a victim or participant, you need to watch it. Okay, because the text of the statute is the law. They cannot go outside the law. If they go outside the law, what are they? Outlaws. They're criminals. If that language is clear and unambiguous, the plain meaning of those words is applied. But if the plain language leads to an absurd results that the legislature could not possibly have intended, or if the language is ambiguous, we may consider extra-textual factors to determine the statute's meaning. Okay? So when I'm learning all this law, folks, and I run across these terms right here, extra-textual factor, I got to go look that stuff up. And that's what I did. I had to go learn what all of these little legalese words meant. So now when I see them, I already know what they mean. But for you, the layperson, when you see stuff like this, you just apply your old, kindergarten, elementary school, junior high school, middle school application of what your definition is that you were taught, program, institutionalized to. Well, they have different meanings when it comes to law. As we scroll down, Section 4909E reads as follows, and this is from September 1st, 2001 to August 31st, 2003. Okay? So in that 2-year time span, if you committed an offense of DWI, you fall into that 2-year law, which must be followed. Except as provided by subsection F, a conviction may not be used for purposes of enhancement under this section if the conviction was a final conviction under subsection D, the offense was for which the person is being tried was what? Committed more than 10 years after the latest of. Okay? The date on which the judgment was entered for the previous conviction. And now I want you to look at this A, B, C, and D, because this is where everybody got fucking confused at the district attorney and county attorney's offices, because these are elements of the offense right here. You're looking at it. But guess what? They were too lazy to do. Go do their research and look through the prior what, Floyd? What is the only thing that matters when it comes to law? The fucking record. They were too lazy to go pull the records in these other jurisdictions or even in their own jurisdiction to what? Get this information. So let's go through this information that they failed to go get, allege, and prove to the trier of fact, case in chief, all the elements of the offense to secure felony conviction. 4909E reads as follows: except as provided by subsection F, this conviction may not be used for purposes of enhancement if under this section the conviction was a final conviction under subsection D. The offense, number 2, the offense for which the person is being tried was committed more than 10 years after the latest of the date on which the judgment was entered for the previous conviction. The date on which the person was discharged from any period of community supervision, probation, on which the person was placed for the previous conviction. So they actually had to go dig through the records and find out the date that they were discharged from any probation. So this could be very lengthy because they could have their probation revoked and then reinstated, and a lot of minutia here. The date on which the person successfully completed any term of parole on which the person was released after serving a portion of the term for which the person was sentenced for the previous conviction, or the date on which the person completed serving any term for which the person was confined or imprisoned for the previous conviction. And number 3, the person has not been convicted of an offense under section 4904. That's driving, boating, aircraft, watercraft, assembling a amusement ride, or intoxication, assault, or any offense related to the operating of a motor vehicle while intoxicated within 10 years of the latest date under subdivision 2. What? Initially, the statute states that a conviction may not be used for purposes of enhancement under this section if this phrase refers to one conviction, not 2. The statute does not say 2 convictions may be used for purposes of enhancement if. Therefore, it applies to prior convictions individually, not collectively. The statute provides a framework for determining if either of Getz's prior convictions is available for enhancement. We must consider one prior conviction at a time. We will begin with Getz's 1984 prior conviction. So we'll just compare this with mine from 1987. The easiest way to understand this statute is to plug the relevant facts into it and then read it. So every time the statute refers to the previous conviction, we will plug in the 1984 conviction. When it refers to the current offense, we will plug in Getz's 2002 offense. We will also plug in Getz every time the statute refers to the person. Now, the statute reads as follows. The 1984 conviction may not be used for purposes of enhancement if the 1984 conviction was a final conviction under subsection D. The 2002 offense was committed more than 10 years after the latest date of the date on which the 1984 judgment was entered, the date on which Getz was discharged from probation, the date on which he successfully completed any period of parole, the date on which Getz completed serving any term for which he was confined in prison. Getz has not been convicted of any other offense related to operating a vehicle while intoxicated within 10 years of the latest date of subdivision 2. The next step in filling in the blanks is to determine under subsection 2 the latest of A, B, C, or D. And what are A, B, C, D? Right here. Let me go back up a little bit more. There we go. A, B, C, or D. The date the judgment was entered, date probation, date parole, or date they just got out of jail or prison. Okay, so here we go. A, B, C, D. 4, the 1984 conviction. In that case, Getz was convicted of a DWI on April 26, 1984. The record reflects that he served 3 days in jail after being convicted, apparently due to credit for time in custody awaiting trial. He did not receive community supervision or parole. Instead, he discharged the sentence after 3 days. So the latest date under those 4 options is D, the date he completed his term. That date is April 29th, 1984. Now we can read the statute as follows. The 1984 conviction may not be used for purposes of enhancement if the 1984 conviction was the final conviction under subsection D. The 2002 offense was committed more than 10 years after the date of April 29th, 1984. And Getz has not been convicted of any other offense related to operation of a motor vehicle while intoxicated within 10 years of April 29th, 1984. We now must consider subsection 3, whether Getz was convicted of another alcohol-related offense within 10 years of April 29th, 1984. The record reflects that he was convicted of a DWI on September 1st or September 11th, 1997. That is more than 10 years from April 29th, 1984. No other alcohol-related offenses in the record. Under the statute, all 3 conditions must be met for the conviction to be unavailable for enhancement. Otherwise, the conviction is available for enhancement. In this case, all 3 conditions are met. The 84 conviction is a final conviction. The 2002 offense was committed more than 10 years after April 29, 1984. Getz was not convicted of another alcohol-related offense within 10 years of April 29, 1984. Because all 3 conditions are met, the 1984 conviction is what? Unavailable for enhancement. And without that conviction, the current offense ceases to be a felony DWI. There's no need to apply the statute to the 1997 conviction because both prior convictions are needed to elevate the offense to a felony. The 1984 conviction is unavailable. No absurd result. The state concedes that this is what the literal text of the statute provides. It argues, however, that this creates an absurd result. The state points out that under this interpretation, a 100-year-old conviction could be used if the defendant also had a 90-year-old conviction, but a 12-year-old conviction cannot be used if the other conviction is just 1 year old. The state's assessment is correct, but we disagree that this result is absurd. There is nothing absurd about a statutory interpretation which results in certain prior convictions being available for enhancement purposes and others not being available. Indeed, our interpretation of the statute is not all that different from the state's. The appendix is useful in comparing the 2 interpretations. It takes each possible set of facts and demonstrates whether the convictions would be available for enhancement under the state's interpretation of the statute and under our own interpretation. For simplicity's sake, the latest date of the 4 options under 4909E2 is referred to simply as the discharge date. As is evident from the appendix, the state differs from us in only 2 situations, situations C and D. In situation C, the state would find neither conviction available for enhancement, and we find both available. In situation D, the state would find both convictions available for enhancement. We find that only the most recent conviction is available. But in the remaining situations, the interpretations are identical. The state's fear of our own interpretation having drastic narrowing effect on the law is unwarranted. For the most part, the results are no different. Legislative history, and this breaks it down, okay, about how they've changed this bill so many fucking times. But the final version of House Bill 2250 made an additional change, one that seems minor, but actually had a tremendous effect on the law. That version change was the pre-2001 version of 4909E2 into what is now 4909E3. The previous version said the person has not been convicted of an offense under any intoxicated penal provision committed within 10 years before the date on which the offense is being tried was committed. Let me repeat that. The person has not been convicted of an offense under any intoxicated related penal provision committed within 10 years before the date on which the offense where the person is being tried was committed. The person has not been convicted of an offense that was committed within 10 years. Okay. So how this works is you go to your primary offense of January 10th, 2001, and you go back 10 years. You had to have committed another DWI and be finally convicted of that DWI. Those are the two elements that they are talking about here with the commission date within 10 years. So my 1994 DWI would have to have been committed within 10 years of September 1st, 2001, which means you could go all the way back to August 31st of 1991. So if I was committed another offense, which is what? An essential element, the commission date, right? Because you see him talk about commissions. It must be alleged in the indictment and proven to the trier of fact beyond a reasonable doubt, right? The version created by the enrolled version of House Bill 2255 says, blah, blah, blah. The person has not been convicted of an offense under blah, blah, blah within 10 years of the latest date under subsection 2. The state concedes that this change is significant. The previous version measured the time between the date the prior offense was committed and the date that the current offense was committed. The amended version measures the time between the date of the conviction for the prior offense and the date listed under subdivision 2. And subdivision 2 refers to the latest date for a previous conviction, not the current offense. So this portion of the statute now measures a completely different time period than it did before. Absolutely, 110%. They amended it September 1st, 2001. They amended it again September 1st, 2003. They amended it again in 2005. I've shown you that. Why? They keep changing the elements of the offense to what? Put more repeat DWI offenders behind bars. This change was made in what Senator Moncrief described during a public hearing as quote, a floor amendment that merely removes duplicative language and makes appropriate technical cleanups, but no substantive changes, close quote. He then described it on the House floor in the following manner, quote, merely a legislative council cleanup, removes duplicative language, makes no substantive changes to the bill, close quote. The problem is, as the state acknowledges, he was wrong. Imagine that. I told you, this corruption goes all the fucking way to the top. And I'm sick and tired of it. I want something done about this. This is fucking lunacy for everybody to continue to operate in this corporate structure that we think is a common law government. We've all been duped. We've all been had. We all concede every fucking day. If you're not protesting, if you're not filing charges, if you're not filing affidavits trying to hold these fucking people accountable, you're complicit too. You're lazy. You don't want any change. You like being governed. You like being a slave. I don't. I'm done with this bullshit because this is bullshit. Even though my little old parole, all I got to do is call in every 2 months and have a chit chat with my parole officer and tell him, hey, nothing's changed. Living Groundhog's Day. It's principle. This is fraud and corruption. They owe me big time. Let's continue. As I keep telling you, regardless of what he or the legislative council, okay, if y'all don't know what legislative councils are, I encourage each and every one of you to go look up ALEC, A-L-E-C, and it's probably alec.org. And I believe that stands for the American Legislative Executive Council or something like that. Those people draft bills and submit them to legislatures and Congress to get drafted into law. That's where your castle doctrine came from. Stand your ground. Where does that leave a court attempting to interpret a statute? The state argues that we should follow the legislature's intent regardless of what it wrote. Okay? This is how corrupt your state is. They are not seeking fair, impartial justice and due process. They are seeking a conviction over due process. These are your friends, your family, your co-workers that are in these positions in government that are fucking people over and committing criminal acts. And in my own view, they are satanic, evil perpetrators upon humanity. If you're not seeking fairness and due process for every individual, regardless of the charges, you're a fucking criminal yourself, and you should go to death row. That's how I look at it. Because you've been elevated to a position of trustworthiness. And when you sully that trustworthiness, you should be held to a higher account. But we interpret the legislature's statutes, not its intentions. This is where the Chevron comes in, okay? Remember the Chevron case that was recently decided by the United States Supreme Court, which stripped all departments, agencies, and bureaus of the federal government of their policies and rules that act outside of congressional intent and laws signed by the president or enacted through Congress majority. This is what they're talking about. So we must give effect to the legislature's change in the law, regardless of whether the change was intended. As the Supreme Court reminded us earlier this year, quote, if Congress enacted into law something different from what is intended, then it should amend the statute to conform it to its intent. It is beyond our province to rescue Congress from its drafting errors and to provide for what we might think is the preferred result, close quote. The D.C. Circuit explains. Okay, remember, this is back in early 2005. The Texas Court of Criminal Appeals observed this and put it right here in this case. The D.C. Circuit explains, quote, whatever degree of confidence about congressional purpose one derives from the legislative history, that purpose must find expression, and again, quote, within the permissible limits of the language, close quote, but still quoting, before it can be given effect, close quote. In this case, it may have been the legislature's intent to make merely technical, non-substantive changes in the floor amendment to House Bill 2250. Instead, it made substantive changes to the law, which we must consider in our interpretation of the statute. Conclusion. Here we go. The plain language of 4909E is clear, and it does not lead to an absurd result. We affirm the judgment of the Court of Appeals. This is the presiding judge. She's the chief judge of the Court of Criminal Appeals, Sharon Keller. Jay Myers dissented without opinion, which means they just dissented, decided they didn't want to tell you why. Justice Jane Cochran filed her dissenting opinion. And Judge Cochran filed dissenting, in which Keller and Myers joined. So they just adopted her dissenting opinion. And we can go into the dissent. No need to. Let's look at the historical overview of DWI enhancements. Although DWI is normally a misdemeanor offense, when a person has 2 prior DWI convictions, the third DWI may be charged or may be elevated to a felony. The public policy rationales for increased penalties for repeat DWI offenders include: repeat offenders should be punished more severely for repeated endangering the public welfare. Harsher penalties for repeat offenders function as a deterrent, discouraging the offender and others from drinking and driving. Well, that worked. And number 3, the jail sentence for repeat offenders reflects the need to physically remove drunk drivers from public streets for a period of time, both as punishment for them as protection for the rest of society. Historically, Texas law provided that any one prior driving while intoxicated conviction, no matter how remote, could enhance a misdemeanor DWI offense to a felony. In 1983, that requirement was increased to 2 prior DWI convictions. Then, in 1993, Whitmire rewrote the penal code. The legislature limited the elevation of a DWI to a felony only when the defendant had 2 prior DWI convictions, one of which had been what? Committed within the 10-year period before the commission of the present offense. Under the 1993 law, the 10-year remoteness clock began ticking backwards from the date of the present offense to the date the person committed their most recent prior DWI. Okay? So basically, what they are stating is that they went to the remote, the furthest out. So let's just say a DWI from 1970. So they went back to that 1970, and then the remoteness began ticking backwards. Okay, so they came up 10 years. And this is all the breakdown, case law, the holdings regarding all this. I read all these. And this breaks it all down for you. The 2001 amendments to the DWI enhancement statute. So now we're getting into Fearless Floyd territory. In 2001, the legislature made changes to 3 provisions within Section 4909. First, any prior intoxicated manslaughter conviction, regardless of whether it involved the use of a car, plane, boat, amusement ride, elevates to a 3rd-degree felony. Second, in any intoxicated manslaughter conviction, no matter how remote, can be used to enhance the present DWI offense. Third, the legislature amended Section 4909E, the provision we are now charged with interpreting, to modify the 10-year time period to begin after the individual sentence is completely discharged. The first 2 amendments broaden the enhancement provisions considerably by allowing for the use of any prior intoxication manslaughter convictions for enhancement, regardless of the type of remoteness. At issue in this case is whether the legislature's change to Section 4909E broadened or drastically restricted the use of prior DWI convictions when there are 2 prior convictions rather than simply 1. This is Boykin. In interpreting a statute under Boykin, we first look to the plain language used. Okay, this is what's called a standard of law. Okay, they have to go look to Boykin for the standard of how they address this issue. So, amended Section 4909E states that a prior DWI conviction may not be used for enhancement if the conviction was a final conviction under subsection D. The offense for which the person is being tried was committed more than 10 years after the latest of, and here we go with these dates again. Okay. The date on the judgment was entered for the previous conviction, the date on which the person was discharged from probation, the date that they successfully served parole, the date on which they completed their jail or prison sentence. 3, the date the person has not been convicted of any offense related to operation of a motor vehicle while intoxicated within 10 years of the latest date of. Under subsections A through D, the legislature unambiguously changed the time at which the prior conviction clock begins ticking. Formally, which is the September 1st, 1994 through August 31st, 2001 amendment, when Whitmire revised the transportation code into the penal code. Okay, formally, this doesn't talk about my case. Formally, it had been the date of the commission of the offense. Now, it is a much later date. Whichever date of the latest date of the judgment, termination of community supervision, or parole, or release from jail or prison. That change clearly broadens the use of a single prior conviction because it moves forward closer to the time of the present offense what's called a 10-year window. Suppose, for example, that the defendant is charged with a DWI alleged to have occurred November 1st, 2004. Well, that is a bad analogy because that comes after the 2003 amendment. Okay, so it doesn't apply to what we're talking about here, but let's continue. He has a prior conviction for DWI, which was committed on November 1st, 1990. Under the pre-2001 amendment, that prior conviction is too remote to use as enhancement. But under the 2001 amendments, if the defendant was not sentenced for the 1990 DWI until November 10th, 1992, and then served 2 years of community supervision for the person community terminated on November 9th, 1994, that prior conviction can be used for enhancement purposes. Okay? The difficulty interpreting subsection E is deciding how it applies when the defendant has two prior DWI convictions. Does the clock run backward as it did under the prior law and as it does for a single prior conviction to the date that the most recent prior conviction sentence expires, and if that conviction is not remote, revitalize any other earlier convictions? Or does the clock, for purposes of the two prior DWI convictions, now run forward, not backwards, to measure only the 10-year interval between the first and second prior convictions? The Court of Appeals said that the clock now runs forward from the earliest prior conviction. It reasoned that appellant's 1984 conviction for DWI meets each of the requirements for remoteness because, one, the conviction was a final conviction, and which means his appeals ran out and they issued what? A mandate, final judgment. Number two, the 2000 DWI offense was committed more than 10 years after the 1984 date of conviction for the DWI. And three, the 1997 DWI conviction did not occur, was not committed within 10 years of the 84 conviction. Several of the courts of appeals have followed the reasoning of the Tyler Court of Appeals. They have stated that under the pre-2001 amendments, the proper approach was to look back 10 years from the date of the primary offense to determine whether an intervening DWI conviction had occurred since the remote conviction. After the 2001 amendments, however, these courts reasoned that they are required to what? Look forward from the earliest of the prior convictions to see if there's an intervening conviction within 10 years of that earliest conviction. Viewed in a vacuum, this is a reasonable reading of the literal words of the statute. However, I think that the plain language of the statute is ambiguous under Boykin because there are at least three other reasonable interpretations of the plain language in the amended statute. First, as suggested during oral arguments on this case, the statute could be read to mean that the two prior DWIs both had to be within 10 years of the present offense before they could be used for felony enhancement purposes. Second, the amended statute could be read to require chaining of prior convictions. The sentence on each prior DWI conviction used to enhance must be completed within 10 years of the next one. Third, as Professor Dixon Dawson, y'all don't know who they are, Dixon Dawson read this amended statute. It could mean that, quote, if the state proves two prior DWI convictions and the date of either conviction is not more than 10 years before the commission of the primary offense, the state may elevate this offense to a felony. And you're going to see they poo-poo that. The extra textual considerations and legislative intent, because each one of these four plain language interpretations is plausible, I believe that the statute is ambiguous under Boykin. Therefore, I would look to extra textual considerations to determine the intent of legislature. The Code of Construction Act, if y'all haven't read that, go read it. I did, which provides the tools for interpretation when the plain language of a law is ambiguous. states that in construing a statute, a court may consider objects sought to be attained, circumstances under which statute was enacted, legislative history, common law or former statutory provisions, including laws on the same or similar subjects, consequences of a particular construction, administrative construction of the statute, and title, preamble, and emergency provisions. I would apply the first two factors, the object to be attained and the circumstances under which the statute was enacted together because of their similarity. In this instance, the 2001 legislature's first two amendments to Section 4909 show the expansion of offenses in any and all prior intoxicated manslaughter convictions, regardless of remoteness, and the broadening of the time window, triggering the enhancement of the charged DWI offense, increasing it from the date of the commission of the prior offense to the latest date for which any sentence would affect the defendant. Additionally, the circumstances under which the 2001 amendments were enacted further support legislative intent to broaden the scope of eligible offenses used for enhancement purposes. The bill analysis of HB House Bill 314 clarifies the background purpose for the 2001 amendments as stating, under current laws, if an individual is convicted of a third DWI within 10 years of the date of the previous offense was committed, okay, the offense is increased to a third-degree felony offense. However, the 10-year period begins with the individual's incarceration and could be partially or completely executed during the individual's confinement. House Bill 314 modifies the 10-year time period to begin after the individual's sentence is completely discharged and authorize a previous conviction of intoxication manslaughter to be used for the purpose of enhancement regardless when the conviction occurred. Thus, the amendment stated for the purpose to broaden the scope of the DWI convictions that can be used for enhancement purposes. Further, the legislative history of the 2001 amendment also reflects a broadening purpose. The original version of House Bill 2255, the bill that eventually created the amendment to 4909E, addressed only intoxication manslaughter. However, HB 2250 was amended by the addition of the language from House Bill 314 discussed above, which modified the 10-year rule and was the basis for the present version of 4909E. The current language interpretation dilemma was created by a floor amendment to House Bill 2255 by Senator Moncrief. Senator Moncrief's introduction of the House Bill 2250 stated the proposed amendment was a way of closing loopholes in the previous DWI enhancement statute. He explained, we already know he was wrong, right? And we can just read all this bullshit. You can go read it if you want. There is no indication from any source that the legislature intended the type of radical revision and limitation of the DWI felony enhancement statute that would occur under the interpretation given by the majority of the Court of Appeals or by the first two alternate plain language possibilities. Both prior DWIs within a single 10-year window before the commission date of the charged offense or chaining of DWIs with each prior within the 10 years of the one before it. The interpretation given by the majority of the Court of Appeals in this case has an additional deleterious effect. It unduly emphasizes the sins of one's youth without regard for the most recent reformation because two very remote DWIs would permit enhancement to a felony as long as both of those prior DWIs convictions occurred within the 10-year window. As the state prosecuting attorney points out, under this interpretation, a teenager could have two DWI convictions in the halcyon days of his youth, then lead an exemplary life for the next 40 years, and celebrating his 60th birthday, commit a new offense. He could be charged with a felony DWI. On the other hand, the town drunk who finishes each of his five prior DWI sentences exactly 11 years apart, except for the most recent one, which was just 2 years before the present offense, could not be charged with a felony. I cannot agree that the majority's interpretation accords with the legislative intent or that the other two simultaneous amendments to Section 4909 would significantly broaden the use of intoxication manslaughter convictions to enhance DWI to a felony. I think the legislature intended to broaden, not drastically limit prior DWI's convictions for enhancement purposes. The majority quotes the Supreme Court's recent statement that if Congress enacted, which we already read. Furthermore, under the literal plain meaning of the words, no conviction obtained before September 1st, 1994 is barred for enhancement purposes under the statute. As the state aptly points out under Section 4909E1, the 10-year rule prohibits the use of a prior DWI only if, quote, the conviction was a final conviction under subsection D. Subsection D, however, refers only to convictions occurring on or before September 1st, 2000, or September 1st, 1994. Therefore, under a purely technical application of the plain meaning rule, no conviction, regardless of how remote, obtained before that date is barred from use under the subsection E. Now, of course, that is not all what the legislature intended. The clear intent of subsection D is to include within the definition of a final conviction any conviction obtained after September 1st, 1994, whose sentence was probated as well as in which the sentence was imposed. But that is not what the literal words of the statute say. If we are to adhere to the plain meaning of the literal words in one subsection of Article 4909, we should, for the sake of consistency, adhere to the technical plain meaning in the other pertinent section of Article 4909. But in neither subsection would strict application of the literal words of the statute be reasonable interpretation of the law or one that is in accord with legislative intent. In sum, I would find that the most reasonable interpretation of the 2001 amendments is that of Professors Dix and Dawson. That interpretation is also the most faithful to legislative intent in history. Although the language of the 2001 amendment to the statute is inflacious, I believe that the relevant 10-year period under Section 4909E is the time from the commission of the present DWI offense backwards to the date on which the defendant was discharged from probation, parole, confinement for the most recent prior offense. If that conviction was discharged within 10 years of the present offense, it revitalizes any other earlier DWI conviction, regardless of the date it was committed for enhancement purposes. I would reverse the decision by the Court of Appeals and affirm the judgment of the trial court. And I can go on and on and on. Both prior convictions states view, our view, a discharge date, one prior conviction, both prior within 10 years of the current offense. The other prior convictions available. That's just a bunch of mumbo jumbo. So that's the opinion. Let's go see what summaries look like. Oh, these are other cases. See if I know any of these people. I'll be right back. Rodriguez, nope. All right. So, did Weaver? I did that. So let me go over here. Get this up and running. All right. Here you go, folks. This is an indictment. This is my indictment. State of Texas versus Floyd Pleasant Tarvin. Driving while intoxicated. Here's my case number, 81716. There's my court, 351st. My bail was $10,000 until they revoked it December 23rd to $50,000 after they issued this indictment. Arresting agency, HPD. What is that? CJIS tracking number. Woo, uh-oh. There we go, folks. In the name and by the authority of the state of Texas, the duly organized grand jury of the Harris County, Texas presents in the District Court of Harris County, Texas, that in Harris County, Texas, Floyd P. Tarvin, hereinafter style the defendant heretofore on or about July 10th, 2001, did then and there unlawfully while intoxicated, namely not having the normal use of his mental and physical faculties by the reason of the induction of alcohol into his body, operated a motor vehicle in a public place. Do you see anything about a BAC of 0.0 or greater? Absolutely not. This is what they convicted me of, having lost my mental and or physical faculties. Now you see why Kelli Johnson skated, because she obviously lost her physical faculties and mental faculties because she could not drive. She got pulled over as probable cause for reckless driving at the very least. Are you seeing a pattern? It is further presented that before the commission of the offense here and above, July 10th, 2001, alleged committed on or about that date, the defendant on December 20th, 1994, in the County Criminal Court at Law number 13 of Harris County, Texas, in cause number 9442241, was convicted of the offense of operating a motor vehicle while intoxicated, which is a misdemeanor offense. It is further presented before the commission of the offense here and above alleged that on or about July 10th, 2001, the defendant on July 22nd, 1987, in the County Criminal Court at Law number 8 of Harris County, Texas, in cause number 950-948, was convicted of the offense of operating a motor vehicle while intoxicated. So this one right here, I was sentenced to 30 days in jail and a $100 fine. But because I was sentenced on July 22nd, I was already in custody because I pled out in early July to a case down here. Okay. So what you don't see in here, what? You see a conviction date. Do you see a commission date? Do you see a date that I discharged my sentence? Do you see a date I was discharged from probation? Do you see a date that I was anything? You just see 2 conviction dates. Well, guess what they didn't meet? The essential elements of the offense. Because they had to prove that I committed another DWI within 10 years of July 10th, 2001. They have to allege it in the indictment and prove it beyond a reasonable doubt to the trier of fact. All they did was present and prove 2 prior convictions, which do not meet all the essential elements of 4909E 1 and 2. Before the commission of the offense alleged above here and styled the primary offense on May 6, 1982, in cause number 344512 in the 262nd District Court of Harris County, Texas, defendant was convicted of felony involuntary manslaughter. I told you folks I used to be a fucking idiot. I was an alcoholic. Late one night after clubbing, I apparently ran over somebody. Don't remember a thing. I remember everything up to that event and waking up in jail the next morning with somebody that I used to work with at, or no, that was a different time. Imagine that. Before the commission of the primary offense, after the conviction and cause number, and what you see right here, folks, what does that say? MKE. That stands for Mark Kent Ellis. Who is Mark Kent Ellis? Mark Kent Ellis was my presiding judge over the 351st Judicial District Court. What do you see here? This is a fucking indictment. Do you know who by law is the only person allowed to an amended indictment? Do you know? The fucking prosecution. And it's called, the legal technical term is interlineation. They are to draw one line through the amended or not detracted, redacted verbiage. So they draw a line through it, write what they want, initial it or sign it, and date it. Well, guess who the fucking prosecution is? My goddamn judge. He has no legal authority to do this, but there it is in his own fucking handwriting. This is how corrupt these fucking people are. This is atrocious. This is appalling. This is the shit that I went through. Imagine going through my case and finding all this stuff going, man, I just got fucked every six ways to Sunday. So, am I proud of this? Fuck no. But it made me who I am. It made me be able to break this down for you and show you what the fuck is what. So, let me go over here, get back to where I was. Whoops, wrong one. That's the indictment. Come on. All right. I told you guys I was going to show you a mandate. Bam. Court of Appeals, First District of Texas, mandate to the 351st District Court of Harris County, Texas. Greetings. Before our Court of Appeals for the First District of Texas on this date, February 19, 2004, the cause upon appeal to revise or reverse your judgment between Floyd Pleasant Tarvin, the fourth appellant. There's my appeal number. State of Texas appealee, appeal from the 351st District Court, Harris County, Texas. Panel consists of Justice Taft, Keys, and Bland. And this guy actually, I'm going to leave that alone. But these are some fucking more corrupt fucking assholes. Was determined, and therein our said court made it its order in these words. Quote, the cause heard today by the court is an appeal from the judgment signed by the court below on August 15th, 2002. After submitting the cause and inspecting the record of the court below, it is of the opinion of this court that there is no reversible error in the judgment. It is therefore considered adjudged and ordered that the judgment of the court below be in all things affirmed. And the mandate issues, which means it's a final judgment. It is further ordered that the decision be certified below for observant. Judgment rendered by the panel consisted of Justices Taft, Keys, and Bland. Wherefore, we command you to observe the order of our said Court of Appeals for the First District of Texas in this behalf, and in all things have it duly recognized, obeyed, and executed. Witness the Honorable Sherry Raddick, Chief Justice of the Court of Appeals, with the seal thereof affixed at the City of Houston on this date, December 10th, 2004. Margie Thompson, Clerk of the First Court of Appeals. There you go. That's what a mandate looks like. A mandate issues when you have exhausted your appellate remedies. That means your direct appeal. That means in Texas, we have a courts of appeals, 14 of them, that's a buffer between the Texas Court of Criminal Appeals, which is the highest criminal court, and the Texas Supreme Court. So you have to go through there on your direct appeal. Then you do a petition for discretionary review to the Court of Criminal Appeals. And when they shoot your PDR down, if you do not file in the United States Supreme Court after expiration of, I think it's 30 days, I'd have to go refresh my memory on that. Bam! The Court of Appeals will issue the mandate, and that's a final conviction. That's a wrap. You have no more appellate jurisdiction. Now, do you have jurisdiction for a post-conviction remedy in the state and federal level? Yes. Potentially on the state or on the federal level, if you do not lapse your 1 year of equitable tolling to stay in court. And that's a whole nother issue. That's where Christopher Hauser is a legal moron. He doesn't know what the fuck he's doing. He tries to make y'all believe he knows what he's doing. He doesn't know what he's doing. He's an idiot. Okay, here's my opinion. Let me stop sharing, make sure it's fucking sharing. God, I hate this part. In the Court of Appeals for the First District, it was issued February 19, 2004. Tarvin versus Texas from the 351st Court. Memorandum opinion. Appellate Floyd P. Tarvin pleaded not guilty to felony driving while intoxicated offense, having twice previously convicted of DWI. You see, they don't even mention the essential elements. This is how corrupt they are. They can't even act on their own volition to find due process and due course of law or the fairness of justice. These people are criminals. They're satanic. They're evil. They thrive on this monstrosity they call a criminal justice system. At the punishment hearing, the trial court found 2 felony enhancement paragraphs true, including Tarvin's earlier convictions for involuntary manslaughter and possession of a controlled substance with the intent to deliver. The trial court sentenced Tarvin to 60 years confinement. We conclude that Tarvin failed to raise in the trial court his contention that his assessed punishment violates the cruel and unusual punishment provision of the 8th Amendment to the United States Constitution. Moreover, the trial court sentence is not constitutionally infirm. We therefore affirm. This is the argument that my dumbass attorney, Tom Moran of Schneider and McKinney, and that would be Stanley Schneider and Troy McKinney. Troy McKinney is a predominant DWI attorney here in Texas, definitely Houston. He co-wrote the book with my original trial attorney, J. Gary Trichter. I know Troy McKinney. I've spoken to him. And when I got court appointed, Tom Moran, who's one of 4 attorneys from Schneider McKinney, I was like, oh my God, thank God I'm going to fucking get out of prison and I'm going to get this reversed, because I have a real DWI attorney who will actually get down. If he doesn't know anything about DWI, he's got to hand everything over to Troy and let Troy do it. Troy's the expert. But instead, Tom Moran fucked me every way to sideways to Sunday. Tom Moran is a fucking moron. He should be disbarred for filing this fucking garbage. This is what I tell you, folks. I've read their opinions. Their opinions are fucking trash. That's why they hire my buddy, Chris, who did 25 fucking years flat in prison that I was on the WIN unit with. They hire him to do their briefs and petitions and motions. Abso-fucking-lutely. Where's my Bible? I swear to tell truth, whole truth, nothing but truth, so help me God. So help me God. This is where I'm at with this, folks. This is a spiritual battle between good and evil. These people are fucking evil, satanic evil. I can't make it any clearer. They should all be on the fucking courthouse steps right now going, oh my God, we've been duped just like you have. We've been enforcing policy for the corporation and not adjudicating fair, legal, impartial justice according to common law. But no, they're still up there doing their little old bullshit, wearing their little satanic gowns, masquerading as power players. That's all right, though. God's got something for you, folks. I'm talking to you. I live a divine life. God will take care of me. He will make me prevail. If I have to be the front person for all of this, I'm going to expose it for what it is. Cruel and unusual punishment. In its sole issue, now mind you, I personally did my own state post-conviction writ of habeas corpus under Article 1107 of the Texas Code of Criminal Procedure. The entire brief and application was 504 pages. That didn't include the appendix of exhibits, which exceeded 500 pages. It took me over 3 months, all day, every day, all night, every day, drafting that, putting it together. And when I show you my petition for writ of certiorari, you'll kind of get a little gist of the complexity, the focus, the time it takes to put together a legal document to obtain relief. Tarvin contends that a 60-year sentence for DWI violates the cruel and unusual provisions of the 8th Amendment to the United States Constitution because the sentence imposed is 120 times the maximum punishment for an unenhanced offense. U.S. Constitution 8. To preserve error for appellate review, the appellate must make a timely, specific objection at the earliest opportunity to obtain an adverse ruling. My attorney never objected to the sentence. So why are you even bringing this fucking ground up? Because you never fucking read the record. You're an incompetent, licensed bar attorney. Tom Moran of Schneider and McKinney, Troy McKinney, Stanley Schneider. Don't use their firm. Ever. They're trash. Yeah, how's that feel, Troy and Stanley? Okay. They all go to Char Bar, downtown Houston, and they all drink and sit there and cut it up. I know. Why do I know? Because I still have somebody on the inside. I know what these fucking clowns are doing. These fuckers are a joke. How do you fucking bring up something on appellate review that there was never an objection in the court? That's the most... I can't tell you how fucking livid I was when I got this little fucking like 6-page appellate brief that addressed a cruel and unusual punishment that had just been litigated by the United States Supreme Court on the same fucking issue. And now you want to bring it up in a court of appeals when there was no objection, there was no preserved error in my case. And then this fucking sorry cocksucker, Tom Moran, split off to fucking Africa. And I couldn't get in touch with him. And I'm writing his freaking case manager or whoever in his office just livid, appalled, shocked, stunned, disbelief. How I could get fucked again so hard. But yet, there I was. This is when I decided that I was going to fucking learn everything I can. I was going to really, really, really study law. And I did. And this is what these fucking cocksuckers do to you behind the scenes. They stab you in the back, they cut your throat while they're shaking your hand. I can't stand attorneys. They lie to you straight to your fucking face. That's all they know how to do is lie. They go to the Southwest Texas College of Law and learn to lie. Get programmed to lie. They have no integrity, no good faith, no clean hands, no honor. And they definitely are not godlike or godly. They're satanic. 100%. I'm showing you in black and fucking white. I don't make this shit up. I'm showing you my own personal experiences of how you can get just fucked after fucked after fucked after fucked in this system they call a criminal justice system, because that's exactly what it is, a criminal justice system. Why can't it just be a justice system? No, it's got to be criminal because they are criminals. Fuck. Nor did he file a motion for new trial. Accordingly, he has waived this issue. Duh! Tom Moran, moron, you're a fucking idiot. I just proved it. You filed a baseless document into a court of appeals, expecting a different outcome because you're a legal moron. Thank God I didn't pay you a fucking dime. And the state of Texas should ask for their fucking money back for your representation that you charged them to do this fucking bullshit ass brief. You fucking loser. Jesus fucking Christ. This, I'm going over it. I'm reliving all this, okay? And it sucks. Even if Tarvin had preserved this complaint, his contention fails. The state need not treat an accused charged under recidivist statute in the same manner as one charged as a first-time offender. What does it say? Rummel versus Estelle, Supreme Court case. Smallwood, Texas Appellate First. The Eighth Amendment does not require strict proportionality between crimes and sentences. Rather, it forbids extreme sentences that are grossly disproportionate to the crime. What is this? Ewing versus California. When? 2003. When is this opinion from Floyd? 2004, February. What happened in 2003 that I told you happened? Fucking Ewing with the United States Supreme Court right here. Now, let's read what Ewing has to say right here. Here's the holding. Rejecting constitutional challenges to 25 years for life imposed on a shoplifter under California's 3 strikes law. What happened to Ewing? Ewing went in and stole some golf clubs. He got 3 strikes. That was in the early 2000s. How do you think fucking Ewing feels now in California penitentiary when they're just letting motherfuckers walk in and out of stores and whatever they want, less than $1,000? How do you think he feels now? He's got to be fucking mortified. And who did that? Who did that? Kamala who? You mean Kamal? Arush? That guy? Masquerading as a woman? Running for president? You folks have been so fucking duped. You don't even know it. Because I had to go back and read Ewing. I was like, what the fuck? In determining whether the sentence is grossly disproportionate, this court considers not only the present offense, but the defendant's criminal history. And the state presented a lengthy account of Tarvin's criminal history during the sentencing hearing. In 1982, a jury convicted Tarvin of voluntary manslaughter for killing a pedestrian while driving while intoxicated. Later that year, nope, not later that year. This was actually 81, okay, when it was committed. I was convicted in 82. So later that year, while out on bond, no, it was in 1982, January 10th, Tarvin robbed a supermarket clerk at gunpoint. I did that. My dumbass classmate, the late Kydell Pearson, me, him, and Willie Copeland, on Willie's 18th birthday, went out on the town to party and celebrate Willie's 18th birthday. Me and Willie got into a contest drinking shots of Jack Daniels. See who could get to 18 first. Well, I won. And I'm drinking jackhammers, double Jack Daniels with a shot of Coke on the rocks in a tall glass. That's what I drank. Me and Willie, fucking, we're blown away. Somehow, this fucking idiot, Kydell, talks me and Willie into going in and robbing a wine gardens. And the fucking guy we're robbing is Howard Roper. Who's Howard Roper? Howard Roper graduated in 1980 from Scarborough with me and fucking Kydell. He's our goddamn classmate. I just spent fucking 6 years with this guy in junior and senior high school. And you got me going and robbing this guy with a fucking gun? Willie with a knife? Are you fucking nuts, Kydell? And I don't even need fucking money. I got cash money laying on the dresser at my house from touring with the fucking Stones. Yeah. So I did a stupid thing. And I paid the price. Later, okay, so we already went through that. The state charged him with aggravated robbery. I got sent to, he was convicted of those 2 offenses, received a 7 years confinement, which I did on the Beto 1, Walls, Hilltop, Clemens, Jester 1, and Jester. No, just those 4. All right. July 1987, he was convicted of possession of a controlled substance with the intent to deliver. I forgot manufacture. and received not a 12-year sentence, a 12.5-year sentence. How did I get a half, Floyd? Well, the prosecutor wanted to give me one of those fucked up numbers, like a 13. I was like, no, I don't want a 13. So, give me shit. I'll take a 15 over a 13. I know that sounds crazy, doesn't it? But I didn't want that code word, that code. So when I got to prison, they were like, 13. Oh, we need to keep that guy here. So guess what me, the prosecutor, and my court-appointed attorney did back in the holding area? Well, I'll tell you what, Mr. Tarvin, we'll flip a coin. If I win, you take 13. You win, take 12. 50-50 shot. Fuck it. Oh, it's tails, Mr. Tarvin. But you know what? I'm in a good mood today. So I'm just going to give you 12.5. Remember, everything I say is under oath. That same month, he was convicted of a second DWI and received 30 days in the Harris County Jail and a $100 fine. Okay. In 1989, Tarvin was convicted of driving while his license was suspended and received 10 days in Harris County Jail. Okay. They don't have to bring all this up, but they do. Because why? They want to put it on the record so people like you can go read it and know what a horrible person I used to be. Absolutely. And I'm not tripping on my past. I don't run away from my past. I did all this. I take full responsibility for my actions. 110%. It turned me into a different person. It took me out of that cyclical addiction to alcohol, to any kind of drug. I didn't give a fuck. There were just a few I was leery of, like GHB, because you can't control the outcome if you consume too much. Heroin, I didn't like heroin. That wasn't a fun drug for me. But everything else, wide fucking open. I didn't care. I didn't have any boundaries. I had no rules, no laws. I did what I wanted to do for however long I wanted to do it. I wasn't scared of knife fights, fist fights, gun fights, gang fights, the police, jail, probation, courts, prison, parole, nothing. Nothing fazed me. I was a 100% moron. I'm not going to say that in 2002, I was a danger to the citizens of Harris County because I had gotten tamed down a little bit, but I was still drinking. I was still doing drugs. And somehow, between January 1st and April 15th of 2016, when I was on the Havens unit, Brownwood, Texas, something clicked. Something said, you can't go be that same person. If you go out there and stub your toe, you're going to be right back here finishing that 60. So I changed my life. I became somebody different. If you had met me 40 years ago and then met me today, I'm a different person. You're like, man, you're not even near the same person. It's crazy. I mean, I can't even stand the smell of alcohol. Somebody opens up a bottle of bourbon, I'm like, ugh, which is crazy because I used to, drink Jack Daniels straight out of the freaking bottle. I mean, I was a beast. Punishment assessed within the statutory limits does not violate federal and state constitutional prohibitions of cruel and unusual punishment. See Samuel Pequeno. The trial court enhanced Tarvin's punishment under the following statute, 1242D, which I've already explained to you guys. Right here. Tarvin's 60-year sentence fell within statutory range. Moreover, given Tarvin's criminal history, we hold the trial court's punishment was not cruel and unusual, and it was not unconstitutionally disproportionate. Conclusion. Tarvin waived any constitutional challenge to the excessiveness of his sentence because he failed to raise it in the trial court. Duh. And therefore, we affirm the judgment of the trial court. Jane Bland, who is a satanic criminal, okay? Absolutely. Now, let me go in here and show you a little something. For those of you hanging with me, thank you for being here. Thank you for hanging. I know this is lengthy. We're already at almost 3 hours, and I still got some more to go. But I wanted to break this down for you, and I want to show you what the fuck is what is really was what. Okay, that's the opinion. I don't know why. There we go. All right. And you're going to have to forgive the, this was scanned. So it's a little crooked. It's got a line through it because of the scanner. But as you see in the Supreme Court of the United States, Floyd P. Tarvin IV, petitioner pro se, State of Texas respondent on petition for writ of certiorari to the Court of Criminal Appeals at Austin, Texas, petition for writ of certiorari, Floyd P. Tarvin, petitioner pro se, John M. Wynn Unit. Video teleconference available upon request and appointment by and through TDCJ John M. Wynn Unit. There's a phone number to the unit. Questions for review. Question 1. Has the state of Texas failed to establish a felony DWI jurisdiction by applying Texas Penal Code 4909B2 and not applying Section 4909E1 and 2 to indict, prove guilt beyond a reasonable doubt, convict and sentence him beyond the statutory allowed maximum sentence for all evidence presented in violation of his 5th, 6th, 14th Amendments to the United States Constitution? Question 2. Has petitioner's due process rights been violated in his felony DWI offense for wanted jurisdiction due to the state of Texas applying Texas Penal Code Section 4909B2 and not applying 4909E1 and 2 to indict, prove guilt beyond a reasonable doubt, convict and sentence him beyond statutory allowed maximum sentence for all evidence presented in violation of his 5th, 6th, and 14th Amendments to the United States Constitution? As you see, I don't bring up the 8th Amendment, cruel and unusual punishment, because it doesn't apply. Has petitioner's right to trial by jury been violated in his felony driving while intoxicated offense for wanted jurisdiction due to the state of Texas applying Texas Penal Code 4909B2? It's the same thing. Question 4. Is petitioner's felony DWI conviction void for wanted jurisdiction due to the state of Texas applying same grounds? Question 5. Is petitioner's felony DWI judgment void for wanted jurisdiction? Same grounds. Question 6. Has the state of Texas failed to establish felony DWI jurisdiction and then fail again to establish felony DWI intoxicated of personal and subject matter jurisdiction, terminating the proceeding, violating his due process rights, right to trial by jury, and voiding both his judgment, sentence, and conviction by 351st Judicial Judge Mark Kent Ellis, MKE, himself, amending petitioner's indictment, violating his 5th, 6th, 14th Amendments, United States Constitution. List of parties. Here we go. State of Texas. They're the respondent. Here's the table of contents, folks. Questions presented. List of parties. Table of contents. Table of authorities. Additional. See, okay. I want y'all to look at this. Okay. This is the relevant authorities that pertain to your jurisdiction. So here in Texas, all courts of appeals cases in Texas, all court of criminal appeals cases from Texas, all district court of appeals from the United States, circuit court of appeals from the United States, Supreme Court from the United States, the codes, criminal codes from Texas, the penal codes from Texas, criminal codes from the United States, Constitution on the state level, Constitution on the United States level, additional legal sources and publications. This is everything else. This is any other DWI law in any other jurisdiction aside from Texas. Okay? These are just suggestions. They hold no authority in Texas. So y'all stop with all that. I'm trying to apply Nebraska law to New Jersey just because you want it to fit. It doesn't fit. That's why I say most of the people that are, cite all this fucking legal shit are fucking morons. They don't know how to read law. They don't know how to write law. They don't know how to research law. It's fucking nuts. opinions of the lower court, jurisdiction, constitution, statutory provisions involved, statement of the case, questions, question 2, question 3, question 4, question 5, question 6, conclusion and prayer, pro se waiver, certificate of service, index to appendices. Appendix A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, X, Z. And I got into the little numbers. So there's 26. There's 52. What does this say? Ricky Lee Jenkins, sworn affidavit certifying exhibits authenticity of appendices. Let's go back up here. What do I have here? Let's see. Okay. Right here, you see indictment of Robert L. Edwards in this cause number. State's motion to leave an amended indictment. Trial court's order setting hearing for that amendment. I went and got other DWI convictions. This is Edwards. I did work on his case. And as we'll go down here, you'll see Bollinger. Well, here's Ricky Lee Jenkins. Same thing, DWI. I believe he fell out of Montgomery County. Here's Eugene Bollinger's. Same thing. Okay. Why are all of somebody else's court documents in my appendix of my petition for writ of certiorari? Why, Floyd? Because all of these people were convicted of felony DWIs. However, the state failed to allege and prove beyond a reasonable doubt the essential elements of a third-degree felony DWI. I told you, I've read countless DWI indictments. Not one is properly drafted. Not one. Here's another one, Rodney Smith. I'm telling you, folks, here are the case citings, okay? These are all courts of appeal cases. They have to be in alphabetical order, as you see. I have to put what page that they appear in this document. You remember, these are just courts of appeal cases that I cite here. Now, I'm fixing to get into the Court of Criminal Appeals. Ding, 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 ding. And guess what? Y'all see all this shit? I had to go read every one of these cases. Every one. We're still going. Now we'll get into the District Court of Appeals for the United States. Circuit Court of Appeals for the United States. Supreme Court of the United States. Y'all should read Almendarez Torres versus the United States, Apprendi versus New Jersey, Arizona versus Folamonte, Blockberger versus the United States. Let's see, there's some more in here. Hey, damn. Floyd quoted Dred Scott versus Sanford. How far does that back go? Yeah, I told y'all. I did some fucking digging while I was in there. What is Ferretta versus California? That's your admonishment for proceeding pro se or pro per. That's what the judge has to do mandatorily if you're going to proceed on your own without counsel. It's called a Ferretta admonishment. French versus Estelle. Henry Winship right here. Hamling versus United States. Haynes versus Kerner. All these are big. Jones versus United States. Barber versus Madison. McMillan versus Pennsylvania. These are big time cases that I'm throwing out here to you guys. Ring versus Arizona. Shad versus Arizona. Most of these that I'm quoting all are on the same topic. United States versus Booker. United States versus Blakely. Remember, these all Supreme Court cases. I had to go read every fucking one of these cases. Every one that you're looking at. Criminal codes. Penal codes. You see how many times I cited 4909. Criminal codes on the federal level. Constitutional amendments. Constitution, articles and amendments of the United States Constitution. Supplemental and other legal sources. J. Bishop, Criminal Procedure, The Complete Anti-Federalist, the works of John Adams, W. Blackstone, Commentaries on the Law of England, the papers of Thomas Jefferson, Texas Jurisprudence, the American Heritage Dictionary of the English Language, New College Edition, 1982. That book is right behind me. Black's Law Dictionary, 7th edition, Black's Law Dictionary, 8th edition. John Adams, diary entry. There's Lefebvre versus Scott, criminal law. I told you I read all this shit. McCormick, evidence. State law of indictments, Marvin Collins and Candace Howell. West, criminal procedure and rules. Stutz, plea bargain and criminal law's disappearing shadow. The Federalist by Alexander Hamilton. Wayne Lefebvre and Gerard Israel, criminal procedure. Lower court opinions, Tarvin versus State, Court of Criminal Appeals, my PDR. Okay. This appeal was done by Tom Moran. Once I got that mandate, I did a PDR. This is when I took over my own legal work. So, petition for discretionary review refused on September 15th, 2004, and it was unpublished. Time extension granted on September 30th, 2004, unpublished. Special motion for rehearing en banc with amended petition for discretionary review. Boom, boom, boom. Jurisdiction. I'll break that down. Constitutional and statutory provisions. Statement of the case, which I've already explained to you guys. Petitioner's 3-day trial concluded on May 22nd, 2002, with a jury finding him guilty of a DWI that had been twice previously convicted of DWIs as presented in his stipulation of evidence. Punishment was elected to be by the trial court, which sentenced petitioner to 60-year term confinement at Texas Department of Criminal Justice Correctional Institution Divisions on August 15th, 2002. Petitioner filed timely notice of appeal in the First Judicial District Court, blah, 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 blah. Y'all know all that. Petition's appointed appellate counsel filed a timely petition for discretionary review and was refused. Petitioner terminated his appellate counsel on August 7th, 2004. He filed his timely extension of time and was granted. He filed a timely special motion, and I filed this writ of certiorari. Reasons for granting the writ. So, Supreme Court must decide a question of jurisdiction arising from the record, though the court's jurisdiction is not. Where a court does not have jurisdiction of subject matter of proceeding is quorum non judice and void. So let's get down here and get to the petitioner now presents this petition for this court to decide these jurisdictional questions that affects every person arrested in the U.S. He brings forth the act that the state of Texas is applying Texas Penal Code Section 4909B2 and not applying Section 4909E1 and 2 as required in the 73rd Texas Legislature's intent. Thus, the state's burden of proof is lessened. Felony jurisdiction is not established. Due process is violated. His right to trial by jury is violated. His conviction is thusly void, and the judgment is void as well. The fact that the state has failed to allege and prove the commission date of the petitioner's intervening prior DWI convictions that had occurred within the 10-year rule of limitations as required by Section 4909E1 and 2, they have not established subject matter jurisdiction of a third-degree felony DWI. Okay. I'm showing you all this, folks. And here we go into the questions. And I told y'all, I know how to write law. I wrote all this. Nobody wrote this for me. No template. If a state makes an increase in defendant's authorized punishment contingent on the finding of a fact, that fact, no matter how the state labels it, must be found by a jury beyond a reasonable doubt. Ring versus Arizona. I told you. Booker versus U.S. The court must perform those collateral judicial duties that the legislator orders it to perform as long as they are constitutionally permissible. Curry versus Wilson. The intent of the 73rd Texas Legislature of 4909E1 and 2 of the Texas Penal Code requires 3 essential elements to trigger a misdemeanor DWI to be enhanced to a felony DWI, 2 prior DWI convictions, and that at least one of the prior DWIs is to be committed within 10 years of the occurrence of the primary DWI, an essential fact that both creates a new offense and raises the punishment level. Without any one of these essential elements, the offense remains a mere misdemeanor. Thus, the gravamen of jurisdiction lies not in the pleading, but in the existence of the facts necessary for the court to exercise its jurisdiction. Giddens versus State of jurisdiction affirmatively appears on the face of the petition. Jurisdiction cannot be inherent. The prosecution has the burden of production of every element of the offense charged. If the government fails to produce sufficient evidence for any element, thereby not bringing the fact into issue, the judge may direct a verdict in the defendant's favor. See generally Lafay versus Scott, McCormick, evidence. Unless doing so would lead to an absurd result. I think we've gone through all this, right? In Getz. So, as you see, I did my motherfucking homework. I put this together. And I go on, 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 and on, and on. Imagine, okay, this is only 73 pages. Imagine 500 and another 500 of appendices, exhibits, which has since been lost. An accusation encompasses each factual element of the crime for which the defendant is accused. See Gaudin, Supreme Court case. The law has distinguished between facts that are elements of the crime and the facts that are relevant only to sentencing. Almendarez-Torres. White versus or Whitty versus United States versus Watts, United States versus Dunnigan, Mistretta versus United States, citing Booker versus U.S. In many cases, as petitioner herein, the prosecution could avoid Apprendi versus New Jersey, which is from Enwi Renship, the problem simply by alleging in the indictment the facts necessary to reach the chosen guideline sentence. Following our decision in Blakely, the Department of Justice advised federal prosecutors to adopt practices that would enable them to charge and prove to the jury facts that increase the statutory maximum. Per memorandum from Christopher H. Wray, Assistant Attorney General, United States Department of Criminal Justice. Well, he became the Director of the FBI. Enhancing the specificity of indictments would be a simple matter. The government has already directed its prosecutors to allege facts in the indictment and prove them to the jury beyond a reasonable doubt. See Booker. Judicial facts. Finding to support an offense level determination or enhancement is only unconstitutional when that finding raises the sentence beyond the sentence that could have lawfully been imposed by reference to facts found by the jury or admitted by the defendant. Booker. Statutory maximum is a maximum a judge or jury may impose without any additional findings of essential facts that would raise the punishment level beyond the maximum allowed. So, if I have a mere misdemeanor and they don't allege all the enhancement essential elements of the commission date, the intervening commission, which is a trigger, to allow them to go back and get that third remote DWI to enhance my primary offense to a third-degree felony. And believe me, folks, when you read some of this case law, people will try to morph it, bend it, amend it to their case so they can get relief. I didn't do that. It was either good law or bad law. There was no gray area. So I'm not going to cite gray law. I'm going to cite positive law. If it's negative, then it's negative. I have no recourse. This is why I ran into problems with doing legal work for other people, because they'd be go talk to some idiot on the side and they would come over, oh, well, you need to do this, Floyd. And I'm like, do what? No, that doesn't even apply. No, but read it again. And I'm like, man, I've read that case before. I just read it again in front of you. And I'm telling you, it doesn't apply. And they would like almost force me to apply it into whatever legal vehicle we were addressing at the time, whether it be an appeal, writ of habeas corpus, whatever. You cannot do that. Any fact such as the commission date that allows increases beyond the 180 days in jail is an element of the offense, and the commission date must now be charged in the petitioner's indictment submitted to the jury. See Winship. Simply because it was the Texas legislature that created the use and non-use of the prior DWIs by its commission date and the 10-year rule, so it may be used to impose a sentence of 30 to 100 days in jail and or a $2,000 fine, or increase the sentence to 2 to 10 years by its use. See Blakely. As Apprendi held, the petitioner has the right to insist that the prosecutor prove to his jury all the facts legally essential to his punishment. Petitioner did bargain about what facts the state would use, as he did in his stipulation of evidence. I presented it. Petitioner simply bargained about what facts would form the basis for his sentencing and proof. See Stunts, Plea Bargaining, Criminal Law's Disappearing Shadow. Harvard Law Review. Booker. Not only is fact bargaining quite common under the current system, it is also clear that prosecutors have substantial bargaining power. As the state may argue that petitioner should have filed a motion to quash, or that he waived any right to pursue this error of the state not alleging or proving the commission date. However, the Texas Constitution plainly provides the right of all criminal defendants not to be compelled to what? Article 1, Section 10, folks. Give evidence against himself. The state, by alleging and proving the commission date, are little inconveniences in the forms of justice that are the price that all free nations must pay for their liberty. See Commentaries on the Laws of England. Citing Booker. The Sixth Amendment requires juries, not judges, to find facts relevant to elevate a sentence beyond the statutory maximum. Texas tolling. Is this a new word in your vocabulary? Tolling. The 10-year rule of limitations. An information indictment is sufficient if it has the following requisites: that the time mentioned must be some date anterior to the presentment of the information indictment and not be so remote that the prosecution of the offense is barred by limitation. See Articles 2021-2102 of the Texas Code of Criminal Procedure, respectively. Everything should be stated in an indictment that is necessary to be proved. Article 21.03 of the Texas Code of Criminal Procedure. I'm just going to say CCP. An indictment shall not be held insufficient, nor shall the trial, the judgment, or other proceedings thereon be affected by reason of any direct defect of form which does not prejudice the substantial rights of the defendant. 2119 CCP. Petitioner's indictment which failed to state year in which DWI was committed was void on its face. See Gibson. See Herrera. See Millard. And therefore could never be proved. The indictment does not charge an offense of third-degree felony. See Gibson. It is the duty of the state to show that the petitioner's prior 1994 DWI was committed within the 10-year statutory period rule. See Cooper versus State. And I can go on and 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 on. How far y'all want to go? We got a long way to go. We're down here at page 73 as it buffers. So what you see here, guess what Fearless Floyd did? He went and fucking did his homework. Oh, Floyd, really? If I can turn that so you can read it. I didn't want to turn. So I'm going to read it sideways. DWI arrests. Felony DWI arrests and convictions in Texas. Floyd went all the way back to 1994, 95, 96, 97, 98, 99, 2002, all the way up to 2004. Why? September 1st, 1994 to August 31st, 2005. DWI arrests, felony DWI convictions, felony DWI convictions, felony DWI convictions. Y'all see these numbers? $109,000, $297,000 total arrests in that almost 10-year period, almost 1 million people. So let's go see what these little asterisks mean, Floyd. Estimated averages. Source is from the Texas Department of Public Safety via the Texas Commission on Alcohol and Drug Abuse. Damn, Floyd, you was a busy motherfucker in prison. You were writing everybody, weren't you? Absolutely. The source is from the, I already did that. Number 2, sources from the Economic Costs of Alcohol and Drug Abuse in Texas, 2000, Texas Commission on Alcohol and Drug Abuse by Liang Y. Liu, PhD, Appendix, Table C7, page 73. Only the year 2000 is a known factor, and all other figures are, I guess that should be 12.62% of the number of the arrest, as in the case of the year 2000. Source is the 10th Special Report to the U.S. Congress on Alcohol and Health, June 2000, U.S. Department of Health and Human Services, page 383, noting that the repeat offenders account for approximately 1/3 of drivers arrested or convicted for DUI each year. NHTSA, National Highway Transportation Safety Administration, 1995. VOAS, RB, and these are the authors who wrote this article. Survey, NHTSA Traffic Task Number 152, Arlington, Virginia, Insurance Institute for Highway Safety, 1997. Number 4, estimated amount taken from 1/3 of the totals in line 3, National Highway Transportation 1/3 estimate, in which in Texas it takes 3 DWIs to equate to a felony status. There are an estimated 77,979 felony DWI convictions in Texas that are questionable convictions due to the state not establishing a felony jurisdiction, and the number could be as high as 109,370 according to the National Highway Transportation Safety Administration numbers. So I back my shit up. So let's go into what? Some definitions. Defining a fact. I went so far as to define what facts are for the court. Elemental fact, see ultimate fact, evidentiary fact, a fact that is necessary for or leads to the determination of an ultimate fact. I told y'all I used to just go through fucking Black's Law's dictionary just to go through it, to learn. Constitution of the United States, Bill of Rights. I even put all this in here in the appendix form. Texas Constitution, Penal Code. Here it is. Objectives of this code. You should go read this. When you read this, you'll be like, Jesus, how are they putting anybody in jail? There's the appendix. Those of you still with me, thank you for being here. I'm trying to get through this as quickly as possible. Now, we're going to go look at the real deal shit. This is an affidavit by Daniel Lee Swank of Huffman, Texas, which is northeast Houston, basically, by Humble. You see, this is in Liberty County. Affidavit of record. I, Daniel Lee Swank, affiant herein, state under Public Law 97-280 that I am competent. I have personal knowledge of the facts herein. State that the facts herein are true, correct, and not misleading. I have retrieved the attached 2 pages of the D&B business background report regarding the for-profit corporate status of the judiciary courts of the state of Texas from Dun & Bradstreet internet website. Further, affiant say nothing. Daniel Lee Swank, State of Liberty County. Here's the notarization for this document. Here's my certification that when I purchased this from Liberty County, from Hope Cross, I have this hard copy. Absolutely. So let's get over here and read this. Let me get my screen share rolling. D&B Business Background Report, Judiciary Courts for the State of Texas, Exhibit A, page 1 of 2. D&B Business Background Report, trademark. Small Business Solutions, D&B. Business Background Report, Judiciary Courts of the State of Texas. Here's their DUNS number. Here's when it was printed, January 29th, 2008. It is a subsidiary of Texas, state of Austin, Texas, P.O. Box 12248. Supreme Court building in Austin, Texas. The year it was started is 1845. That's when the U.S. territory gave the territorial prison in Huntsville, Texas, to the state of Texas. So that's when they created everything. Texas was founded March 2nd or March 3rd, 1836. Total employees, 1,049. All this has changed. As you see, the top executive for the judiciary courts of the state of Texas is the Chief Justice of the Texas Supreme Court, then Thomas R. Phillips. Industry, line of business, state court system, primary SIC, state court system. Business history. The corporate details provided below may have been submitted by the management of the subject business and may not have been verified with the government agency which records such data. Business type, corporation, profit, date incorporated, 00-00-1836, state of incorporation, Texas. Good luck finding them listed in the Secretary of State's office as a corporation. You will not find it. I have attempted to establish a business as the state of Texas in Texas. Absolutely. Guess who I had a conversation with? Yeah, their attorney for the state of Texas. And I clown that fool. I love talking to attorneys. They think they're so fucking smart. And they're fucking idiots. It's hilarious. That's why I encourage every one of you, man, go study law. That way, when these idiots try to buffoon you and bamboozle you with all these legal terminologies and Latin, you know exactly what they're saying. You know the definitions of the words, the real definitions of the words they're using. And you can go back and stomp their ass. Because that's what I love to do. Put attorneys in their motherfucking place, showing them that, hey, that 4 years of college you went and got, and the other 4 years to go get your JD, you're a fucking imbecile. Yeah. Yeah, I can't tell you how many conversations I've had with attorneys over the last 5 years. where they're fucking morons. I'm telling them what to do. I'm advising them. You need to go do this. It's insane. So let's jump over to the last page. I told you folks, man, I bring it to you in black and fucking white, man. I do not, there are no gray areas. So don't look for gray areas over here on my show. Here's page 2 of the DB Background Business Report. As you see, Thomas R. Phillips, Chief Justice of the Texas Supreme Court since 1986. Here's their operations. A subsidiary of the state of Texas, Austin, Texas, started 1845, which operates as a state government. Intercompany relations, none reported by management. As noted, this company is a subsidiary of the state of Texas. State of Inc. DUNS number. Boom. There's your state of Texas DUNS number, folks. And references made to that report for background information on the parent company and its management. State court system, which includes the Supreme Court, Court of Criminal Appeals, Courts of Last Resort, 14 courts of appeals with 80 judges. Those are actually justices, not judges. Judges sit on the Texas Court of Criminal Appeals. Justices sit on the Court of Appeals, as well as the Texas Supreme Court. That's a fact. Sucks being the smartest guy in the room, doesn't it? The district court with 386 judges, criminal district court with 10 judges, and county level courts with 445 judges. And of course, since this document was generated, sworn to, certified, provided to me, these numbers have since greatly increased. Not the number of courts of appeals, Supreme Court, or Court of Criminal Appeals, but definitely the district courts and all lower level courts. Funds derived from what? Tax revenues. How do these parasitic governmental corporate for-profit corporations exist? They're parasitic, greedy, juvenile bullies that suck the fines, fees, and taxes from its citizenry. That's what it's telling you. Employees, 1,049, which includes officers, 64 employed here. Facilities, owned premises in a multi-story building. Location, central business section on Main Street. Branches, department maintains 14 courts of appeals, 375 district level courts, and 420 county level courts. End of Bradstreet Background Business Report. Here's the original certification from 2008. And here's hopes from 2020. You yourself can go get this. If you're looking for it, this is the file number right here, 2008-010522. Just call the Liberty County Clerk's Office, ask for Hope Cross, because it's a very small county clerk's office, and tell her that you want a certified or an exemplified copy of this number, 2008-010522, and you yourself can get a certified copy of this atrocity. 100%. And as I get close to wrapping up here for you folks, now, to file, Judge Powell. That was my presiding judge before the latest one, now Natalia Cornelio, who's also satanic, evil, and corrupt. Who's this attorney? Attorney Thomas P. Moran, not Moran, Moran. So as you see, this is a private communication between the parties. Knows the agent, knows the principal, knows the principal, knows the agent. There's my cause number. There's my name. You see, I filed this in 2020. Greetings. You are hereby ordered, Remedy the enclosed affidavit in your official and or personal capacity. Otherwise, you'll be in violation of your official oath and official bond, therein liable for inaction to this lawful and legal remedy pursuant to the Texas Business Commerce Code, Texas United States Americans Constitutions. I look forward to your response and remedy. Floyd Pleasant Harbin IV. And here you go. And they ignored this, like they ignore everything. So there you go. You got it in a little nutshell, a little bit about Kelli Johnson, a little bit about the corruption and fraud in Harris County, Texas, that emanates all the way up to the C fucking E fucking O, the dishonorable Greg Abbott. Hate to label you that way, Greg. I really do, because, you know, I would like to sit down and have a polite, mature conversation with you. But I don't think that'll ever happen, because when you were the attorneys general and you were in a wheelchair, clearly you enforce the Americans with Disabilities Act because you're in a wheelchair for all of those businesses, establishments, residences that are in violation of the ADA, and then you force them to be compliant. So when I, was in prison and I was under psychiatrist care and taking medication for PTSD, and bipolar depression. After 10 years of being in the building and having litigated and was pretty much done with litigating, I wanted to go be an outside trustee. I wanted to go wander around, you know, have a little bit more freedom than being in a cell block. So I voluntarily took myself off the medication, got cleared through Dr. Yap, my psychiatrist on the WIN unit. So then I submitted to be an outside trustee and was denied because I was on medication. Well, I'm covered under the Americans with Disability Act. You can't discriminate me because I have a mental health issue. So I filed a Title 42, Section 1983 civil rights complaint, as well as all the provisions under the ADA, which at the time Congress had gone back and just rewrote the Americans with Disability Act and made it even stronger. So I'm the plaintiff. Guess who the defendant is? The state of Texas. Guess who's representing the state of Texas? Yeah, that motherfucker in a wheelchair that's disabled called Greg Abbott. Which you would think, because he's fucking disabled and uses the ADA every minute of his life, would say, oh, fuck, we can't fight this. I'm disabled. How would this look if I'm fighting somebody that's trying to get the ADA upheld? But no, he fought me on it and he won. This is how I know that these motherfuckers are corrupt and they're satanic and they don't give a fuck about you. They don't give a fuck about the law. They don't give a fuck about the Constitution. They don't give a fuck about your rights. They care about one motherfucking thing: power, money. That's it. Greg Abbott, career motherfucking politician. Courts of Appeals, Chief Justice of the Texas Supreme Court, Texas Attorney General, Governor. Guess how many pensions that fucker gets? At full salary every fucking year. That idiot's getting like $300,000 to $400,000 every year from his pensions, from his prior elected positions. Are you seeing the big picture now, folks? You see how these people operate, how corrupt, fraudulent, criminal, satanic, unethical, immoral that they really are? These people are the devil incarnate. I've laid it all out here for you. Facts are facts. Law is law. White is white, black is black, and gray is gray. There is no gray area here. So once again, you know, I have the bounty up. Nobody will come claim the bounty because they can't. And this is what's going on all across the nation. These people are insane. They're mentally ill. They've lost their motherfucking minds. And what really sucks is the people that are just employed there who really have no idea what they're participating in. That they're in a satanic cult operating illegally, immorally, unethically, on every level. And when you go in and try to explain it to them, they're not trying to fucking hear it. Oh, you're one of those. You're a sovereign citizen. No, we're just trying to tell you what the fucking law says because you don't know the law, because nobody ever told you you need to know the law and apply the law. They just told you, oh, here's policy. This is what you follow, policy. Standard operating procedure. Not the Texas Penal Code, not the Code of Criminal Procedure, not everything in Vernon's annotated Texas statutes and codes annotated. No. That's why I love talking to lawyers, because they're fucking idiots. They don't even know the law. They go through college and then they skate. They use boilerplate templates. You can go on the Texas Criminal Defense Lawyers Association website and you can download all the free forms you want that those attorneys post up there. So that's where they go for all of their stuff. They just download these forms and they have a legal secretary or paralegal over here and just fill in the blanks. And they submit it. That's how the legal system works, folks. There is no forethought. There is no research. That's why my buddy Chris, who does these legal vehicles for all these criminal defense attorneys, that's why he's winning. Because he actually goes and researches the fucking law. He doesn't use some bullshit boilerplate bar license crap. And listen to me when I tell you this, because remember, everything I tell you is under oath. Jeff Rahm, the Rodriguez Estate asset manager, that motherfucker is dancing on cloud nine. Why? Oh, boom. You're welcome, Jeff. You're welcome. Took me about 10 minutes to solve that case. And you'll hear about it eventually. Not yet. And when we do, we're going to let you know about it. Because all of you are going through the same bullshit. You're going through it with CPS. You're going through it divorce. You're going through it through foreclosures. These people in these courtrooms are fucking criminals. They're fucking pariahs on society. They need to be removed. All of them. We have to start with an education system that's a real education system and not a programming and institutionalization system. That's where it all starts, with the children. Not the children we have now, but those children's children. We have to revamp the entire way of life in this country. Otherwise, we're going to hell, folks. If you haven't already noticed, you're in hell. This is hell on earth. This is Lucifer's domain. Go read the book of Enoch. That's why you have to be in a divine state of mind at all times, a temple of God. You have to represent. You have to be transparent, truthful, honest, integral. Otherwise, you're just a bunch of bullshit. That's why I try to present everything that I am to you guys so that you can't come out and say, oh, Floyd, you didn't tell us about that. No, I told you everything. I'm telling you all. It's public record. Just Google my full name, Floyd Pleasant Tarvin IV. I don't hide a motherfucking thing. I ain't got nothing to hide. I don't want to hide nothing. I'm frustrated with the entire fucking system. This is a fucking joke. Everything's a fucking joke. The crazy went fucking insane, and it ain't coming back. As long as you keep running around with this phantasmagorific, as long as you live in a reality where you believe everything is fucking true and that your government is trying to protect you and serve you, they're trying to serve you for fucking dinner is what they're trying to do. Don't pay your fucking property taxes or school taxes on your real estate and see what happens to it. Fucking government's going to come take it from you because it's theirs. Because they think they own everything because we've allowed them to do that. We've allowed them to flip everything upside down. Go look at the food guide pyramid. That thing's upside down. You should be eating meat. If it comes from an animal, fucking eat it. If it's processed, don't eat it. That's why I say, tell everybody, man, I ain't got no animosity against the cocoa plant that cocaine is derived from. It's a natural occurring element. It's here for a reason. But it's how it's processed and utilized and marketed. It's like weed. Ain't nothing wrong with weed. How many people do you see, oh my God, this guy was all fucking stoned out of his mind and went in and robbed a Wendy's because he was hungry. He had the munchies at 3 o'clock in the morning. You don't hear that shit. But yet they want to persecute it. And I guarantee you, Ewing, sitting over in California doing 25 to 99 life under the 3 strikes law, which I got caught up in as well. He's fucking got to be just every waking moment. He's just got to be sick to his fucking stomach. Can't believe he fucking shoplifting a fucking golf club. And these motherfuckers are out, hitting the Nike store and stealing every tennis shoe that they can carry out. Or they're hitting Louis Vuitton, carrying out, 20 purses. And they don't care if it's over $1,000. I'm telling you, the world's insane. And the only way it's going to change is if you go put on your white hat and make a difference. That if you're expecting your neighbor to put on a white hat and come save your ass, or if you're expecting your state governor or your congressperson or your legislature or your sheriff or your police chief or your mayor or your governor to come save your ass, no. Put your head between your legs, kiss your motherfucking ass goodbye, and give your heart to Jesus. You belong to the parasitic entity that is the corporate government. So don't count on Donald Trump to come right in here with a fucking big white hat and a Stetson and 2 chrome-plated or nickel-plated 6-shooters on his hips and start blasting everybody and cleaning everything up. Ain't gonna happen. It's us. We, me, you. We are the white hats. You're being buffaloed with all these fucking psyops by all these fucking talking heads on social media, filling you full of bullshit. And this is how I vet those talking heads. I want you to go back. Anybody that you follow, and I don't care who they are, I want you to go back through their social media. I'm just going to use YouTube for an example. I want you to go back to September 11th, 2023. September 11th, 2022, September 11th, 2021, September 11th, 2020, 2019. Go back 1 year increments and watch those videos that they produced on that day a year ago. If they're still talking about the same dumb bullshit, or they talked about something that never ever fucking came true, and that's just a repetitive pattern, turn those motherfuckers off. Unsubscribe. Because they're full of fucking shit. That's how you vet somebody. X22, full of shit. Phil Godlewski, full of shit. Michael Jaco, full of shit. All these clowns are full of shit. They just repeat the same shit over and over and over. The white hats are doing this. The white hats are doing that. There's trials. There's executions. Fucking show me. Okay? If all these motherfuckers got such special connection to some fucking intel that they're going to leak, well, leak some fucking videos, motherfucker. Leak some goddamn indictments. Leak some court orders. Leak a judgment and sentence. Don't leak no rumors on rumormill.com and Real Raw News and all these other fucking parrots like Melanie Hines and Judy Byington, who just copy other people's shit and post it. And y'all just like, okay. Don't be a dumb motherfucker. Go learn. Go do your own goddamn research, man. I can't fucking tell you people enough. Don't fall for the fucking okie doke. Yeah, I'm pissed off. A lot of cuss words today. Abso-freaking-lutely. So, tonight, I have a very special video that will be published at 7:30 p.m. Central Standard Time, addressing Scam Anderson, a.k.a. J-Boy, a.k.a. J-Boy Productions, who's a fucking RV grifter, con, liar, scammer, serial harasser, serial cyberstalker, the leader of a criminal street gang as defined by the Texas statutes and codes, as well as the Title 18 USC federal criminal codes. If you're participating with Scam Anderson today, or since I've given my notice, you're in a fucking criminal street gang, and you're just as liable as Sam Anderson. And you're going to hear it all. I'm going to go through all my connections, and please forgive the first part of the video where I'm assuming my screen is sharing and I'm showing you things, but it wasn't sharing. And then you're going to see everything crash. And that was Firefox crashing on me. So once it crashed, it restarted up, and then my screen started sharing. So for about the first 20 minutes of the video, please bear with me. I apologize for that. When I did the original live presentation, I stopped that part and I went and did it live for my audience at that time during a private presentation of that video. It just happens. That's why I had to stop everything with this video. So I want you to go watch that, because you're going to see elder abuse. Okay. This guy preyed upon the senior citizens that are not tech savvy, that are not well researched and well knowledgeable. He's a predator. He's a cyber stalker, not only in the state of Texas, North Carolina, Puerto Rico, wherever John Dowling's based. Yeah. What I'm going to do is hold him accountable on all levels. So the first part of the video is me going through my bona fides to show you I am what I am. I can do what I say, and I know who I know. And then we're going to get into the Texas laws for harassment, cyber stalking, criminal street gangs, Texas RICOs, racketeering influence, corrupt organizations, criminal street gangs, and the statute of limitations, which is 3 years. Then we're going to dive right into the Title 18 United States codes, and we're going to go through that. And I'm going to show every fucking federal law, Scam Anderson and his little clique of criminal minions have committed repeatedly, all the way to the federal RICO statute. I'm going to address it all. Bear with me. It's a shocking video. If you were involved in Sam Boy, J Boy, whatever the fuck that little loser's name is, when I got finished with that private performance, people were on their couch, curled up in a ball, bawling their eyes out, terrified of what the fuck they were involved in for days. For days. I had other people reach out to me, hey man, can you call so-and-so and talk to them? They're just all fucked up. And I did that. I reassured every one of them. Everybody who's reached out to me, I contacted back. There's a couple that I haven't had time to get back with, and I will get back with you. Especially those that have inculpatory evidence against Scam Anderson and his minions that are still over there fucking around so they can find out by playing stupid games and win stupid prizes. I just showed you I'm fully capable of litigating anywhere, everywhere, on all levels. I'm not one you want to fuck with. You get my attention, you're going to get fucked. Because I'm going to come after you with everything that I know, all my contacts, all my resources, whatever that looks like. Oh, wow. Check this out, folks. Did y'all see the endorsement for Donald Trump by the Fraternal Order of Police Officers? Did y'all see that? Do y'all know who the president of the Fraternal Order of Police Officers is? Floyd, do you know that guy? Oh. His name's Joe Gimaldi. I want you to go Google him. And you'll see he's the past president for the Houston Policeman Patrolmen's Union. Yeah. And who did he follow? Ray Hunt. Ray's the past president. What's Ray doing today, Floyd? He's the executive director of the Houston Policeman Patrolmen's Union. You know him? Yeah, he's my former parole officer, former classmate, been to my parents' house multiple times. My dad taught him 9th grade physical science, as well as his older brother, Charlie, who is my 1980 classmate at Scarborough High School, who still works at the Southwest substation on Derry Ashford. You're more than welcome to call and ask for Charlie Hunt. Scam boy. And verify that he still works there. You're more than welcome to go to the Houston Policeman Patrolmen's Union and go look at their board of directors. And scroll all the fucking way down to Ray Hunt. You motherfuckers think I'm playing. Please stay tuned for that video tonight, 7:30 Central, Scam Anderson. Let me show y'all what the thumbnail looks like so y'all can go identify it very easily. And screen share, there we go. Look for this on YouTube, Rumble, Facebook. It's also posted in my Telegram. You can go watch it there. If you don't want to wait for 7:30 tonight, you're going to have to go find it. I may just post it in there early for you guys. Not only is he scamming his memberships and his folks out of money, utilizing his son's youth baseball league team as a front to scam money. He's even told people that you send me $75, I will go buy some Zim dollars My wife will go redeem them, and then we'll pay you out. That is a unlicensed security broker, folks. That's a federal felony. Oh, well, let's get over to his other federal felonies. Soliciting a straw purchase of a firearm. Is Sam doing that? Well, all the little minions that are associated with Scam Anderson right now, guess what you're involved in? Illegal gun trafficking. You motherfuckers gonna find yourself all caught up in a whole bunch of fucking shit you don't want to be in. If you think you're gonna go RV your fucking currency, your ass is gonna be sitting in a fucking county jail somewhere in the United States, if not Puerto Rico, which is a U.S. territory. And I'm gonna do everything in my power to make sure that you have a nice, comfortable 3 hots and a cot and a bunch of diesel therapy. Y'all keep playing with me. Okay? I'm fixing to start putting my binder together this weekend. And when I do, and I go see Ray Hunt, your ass is fucking grass, because we're going to take a trip over to 2600 Travis Street, downtown Houston, which is HPD headquarters. And I'm going to go right to the fucking person I need to talk to for cyber stalking. And I'm going to present them with a fucking binder with every fucking bit of evidence that I have accumulated over the last 2 weeks. I'm going to bury you, Scam Anderson, and your fucking little minions. I'm going to put you in county jail. I'm going to put you in a Texas Department of Criminal Justice Correctional Institution Division where you fucking belong. I'm going to put you in a BOP. I'm going to put you in fucking prison in fucking Puerto Rico and North Carolina for sure, because I have your IP address pinged. I've got screenshots of you fucking bragging about hitting up Mark Z that people have sent me under your pseudonym Skefla. I've got you by the motherfucking balls, you dumb motherfucker. And all you do is keep destroying evidence when you delete all those posts in Telegram that we've already documented. We've already recorded. Yeah. Tampering and fabricating physical evidence. Go look it up, bro. I'm not making shit up. It's in the video tonight. Y'all stay tuned. Thank you everyone for being here. You can always reach me at the Fearless Floyd Show at yahoo.com. I am the Fearless Floyd Show across every social media platform. Mainly, I hang out over on Telegram when I hang out. Most of you know my phone number. You can call me. I've got tons of calls and texts and emails to return that I've been so consumed with doing this video. For Kelli Johnson, I made my offer to you, woman, and you refused. You decided you wanted to take the low road with Lucifer. Well, you're going to pay the consequences, woman, one way or the other. Either society's going to do it, but definitely the divine is going to take care of you, woman, because you didn't take care of your business. You didn't accept responsibility for your actions. You didn't do the right thing when you should have done the right thing, and recuse yourself from all judicial proceedings because what? You were fucking mentally incompetent because you had a traumatic brain injury. Oh, we're back in Joe Biden territory. Oh, I'm sorry. He's too old and senile to convict. Really? Is that how this world's working? That's fraud and corruption. I brought it to you on a silver platter. There it is, folks. It's up to you to put on your white hat, go out and save the motherfucking world. Don't make me do it by myself. I can't do it by myself. I'm going to try, but I can't. I need your help. I need everybody's help. Thanks for watching. I'll see y'all at 7:30 tonight, Central Standard Time. Y'all come over there and hang out, and y'all learn about a cultist, a manipulator, a serial criminal, street gang leader named Scam Anderson. And that's going to stick. From now on, your name is Scam Anderson. J-boy, piece of shit.